Good afternoon. Welcome to the Appellate Division First Department. This afternoon we are pleased to be sitting in Bronx County at the historic New York Supreme Court in Bronx County, located on the Grand Concourse. Not only is the court historic, but this afternoon we have, for the first time in the First Department, an historic panel of judges. We are all judges of Bronx County and all judges of color. So we are very happy. Thank you. We are glad to be here. Also, we have some special visitors with us this afternoon from the Academy of Mount St. Ursula High School, some young women who are here accompanied by their teachers, Ms. Jennifer Brenla and Mr. Steve Costas. The Academy of Mount St. Ursula, I think they're called Mounties, hail from the oldest continuous all-girls high school in Bronx County, and I know that much about them because I am an alum of Mount St. Ursula. We think that these are budding lawyers. We certainly hope that they are not dissuaded by anything they hear today and are only encouraged by the lawyering that they will see and hear today. So thank you for being here. We have a calendar that has more than 7.5 hours of argument time requested this afternoon. So I'm going to ask, please, that when I call and you request your time, please ask only for the time that you'll need to make your most important arguments. Remember that we have your briefs, we have the record, and we are fully familiar with the facts of your cases. First case is People versus Ernesto Collazo. Submitted. Port Morris versus Sangdara.
783 for appellate, Your Honor. 5 minutes for the respondent.
5 and 2 and 5. Ethan M. Submitted. SM and Infant versus Madura. 5, 2, and 5. Rosario versus Cal.
Good afternoon, appellant request 5 and 2.
Counsel, you are the only person here. There's no respondent. Do you wish to argue? You want to argue against yourself? I'll give you 2 minutes, or 2 minutes? 2 minutes and a submission. People versus Shelton Davis. Submitted. Bucci versus the City of New York.
Plaintiff appellant respondent request 5 and 2, Your Honor.
Your Honor, for the Haas appellants, 5 and 2, please.
I don't believe there's a cross appeal. There a cross appeal here? I don't believe so.
I believe there's 3 appeal, 1 appeal, and 2 cross appeals.
Okay, I'll double check.
Your Honor, for the respondent, third-party plaintiff, 10 minutes.
Okay. 5 and 2. 4 and 1. 3 and 1 and 5. Rivera versus B. Yuan is withdrawn. People versus the State of New York versus Annucci.
The appellant request 5 and 2.
5, 2, and 6. People versus Danielle Stepney. Submitted. Cosme versus the City of New York.
Appellant, plaintiff
5 and 1, 4, 3 and 4. Castillo versus TRM Contracting.
Good morning. Appellant requests 5 and 2.
5, 2, and 5. People versus Ricardo Sanchez.
Your Honor, respondent requests 3 minutes, please.
There's no
That will be very
appellant. Okay. Okay, that's a submission, and I'll give you 2 minutes. Chayas versus Grassroots.
Respondent 5 minutes.
5, 2, and 5. Alexi Home versus Union Mutual.
Respondent 5.
5, 1, and 5. DeProspo versus Nixon Cochran. Five and 1, 5 and 1. Diaz versus Klausner. 6, 1, and 5. People versus Jaquan K. People versus Jaquan K. Submitted. San Miguel versus Grimaldi. Five and 2, 4 and 1, and 6. Ferrer versus Williams. Ferrer versus Williams is submitted. The first case for argument is Port Morris versus Sengdara. Please just wait a moment until I get the lights on. Okay, you may begin.
Afternoon, Your Honors. My name is Jeffrey Metz from Adam Lightman Bailey, PC, represent the appellant here, and I'm asking Your Honors this afternoon to modify the trial court order to grant my client a monetary judgment and, as modified, to affirm the order. My job is a little easier here because the case law that I'm relying on all emanates from this department. It goes back 40 years, and it's consistent. You cannot get a free ride when you litigate. And what happened here was the tenant came in, got a Yellowstone injunction. There were no conditions at that time. There was a period of time of 16 months where no money was paid. We made a motion to vacate the Yellowstone injunction or to direct the payment of rent and rent going forward. What the court did, and it starts on page 93, that's the initial order, which I think the judge got right. He followed your decision in the gap and said if you're in possession and you're litigating, you have to pay the rent. So if you look at pages 96 and 97 of the record, there are mandatory directives of payments.
You're asking for use and occupancy for the period during the Yellowstone injunction where the plaintiffs stopped paying. I think when you first went for the Yellowstone, there was no back rent. They were timely. At some point, it
That is
became
correct, Judge.
untimely, and you're asking for the period that during that Yellowstone for those months.
That is exactly right. The order that starts on page 93 from January 4th states that you shall pay. It was a mandatory directive, and it said that—
So let me ask you, did you need to start a non-payment action for this to happen?
No, Judge, no, because the case law from this department, starting from Calvert against— I'll tell you, I'm so old. I was on that case. It's the
I might have
truth.
been a housing court judge at the time. I don't know. In any case, what you're saying
any
is you
event-
don't need a non-payment action here where the court ordered use and occupancy?
That is correct. And as a matter of fact, my adversary put in his brief something that I just want to bring to the court's attention, said that we had a pending non-payment case. That's not the case. Remember, there was a distillery space and a storage space at issue here. It was only with the distillery space, and I gave you the citation in our brief, has nothing to do with this. So what you've got here, you have no excuse for failure to follow the order that the court directed. Now, we have really a multitude of cases that back me up on this.
Well, counsel, is there any water to your adversary's position that you frustrated their use of the property?
Well, Judge, here's the thing. Here's the thing. That's not the issue before you. I'm not ducking a question. Not ducking the question.
They raised it, so I'm just.
My client, I'm going to tell you. My client put in a detailed response initially when they said we shouldn't have to make any payment. And Judge Albert rejected that. They raised this again on the second go-around. Now, the first time where he rejected that, if they had some sort of problem with that, they could have taken an appeal, but they did not do so. So instead of doing that, they just continued not paying my client. Now, my client's a small businessman. They need the money. They need the money. It's unfair that they were in there, they had a Yellowstone injunction, they thwarted termination of the lease for over 3 years, and then when it came time to follow the court's order, couldn't move for contempt. Calvert against Latam says you cannot move for contempt, you move for execution. You also have your case in Rose against Johnson, 313 West 57th Street, and to the extent that my adversary makes this argument that, well, you can't get this kind of relief when you violate a Yellowstone condition, that's not true either. I have 2 cases for you. 61 West 62 Harkness. That was one of my cases when I had a lot more hair. But anyway, that goes back. And then you have the 4504 New Utrecht PETA parlor case. Now, what's interesting about that one is to the extent, let me just back up for a second. The lease between these parties here has a clause that says that there is no set-off or deduction in the payment of rent. It's the law in commercial tenancies is very clear that there are independent covenants. I'll reserve.
Thank you. You have 2 minutes.
Good afternoon. May it please the court. Christopher Ryan Clark from Ginsburg and Misk on behalf of the plaintiff respondent. Your Honors, even though there's a long history between my client, the tenant, and Mr. Metz's clients, the landlords, this is actually a very simple issue before the court. What you have before you is an order initially from Judge Albert conditioning the continuance of a Yellowstone injunction on the payment of back rent and pendite lite rent going forward. The court made it clear that this was not an unequivocal money judgment, but rather a condition for which must be met in order for the Yellowstone injunction to continue.
So, counsel, a Yellowstone injunction typically includes payment of use and occupancy. To the extent that no rent was owed at the time that the injunction was issued, doesn't that make a qualitative difference with respect to your adversary's argument that use and occupancy is actually owed? After all, you got the benefit of staying the termination of the leasehold here.
And we continued to pay rent, even though there was no directive initially.
But then you stopped.
There came a point when my client's business was effectively shuttered because of the inability to close out the certain Department of Buildings violations, et cetera. And we did end up trying to negotiate a surrender, ultimately did surrender.
But what does that have to do with your obligation to pay use and occupancy? That's not the defendant's problem,
The use and occupancy issue is really not part and parcel of this particular order, though, because as the court is well aware, the trial court had brought...
Counsel, you were ordered to pay rent, and your client failed to do so. What am I missing?
That was a condition for the Yellowstone continuing. When we
It's
couldn't,
also a condition of being able to continue to maintain that leasehold. That's just basic, right?
but we surrendered the leasehold. When we couldn't meet the obligation, not only did we give possession back, but we surrendered and said that we couldn't. But more,
And we know that even when you do that, that does not relieve you of your obligation for rent that was due at the time that you submit the surrender.
but that would be part of a separate rent claim or subject to a determination of an actual cause of action for use and occupancy.
So are you saying that the money that was owed prior to the surrender is not due and owing immediately as a money judgment based on the procedural history of this case?
Absolutely, because the directive to pay
And
rent,
what case law do you cite to support that proposition?
all of the cases that
Give me one.
well, Grubard, the one that Judge Albert cited in his order, said that there are, just because there's a determination as to conditions, doesn't necessarily mean that it's going to affect the ultimate rights of the parties in the litigation. So we retained our ability to assert our rent defenses, whether they're successful or not. This is not the appropriate procedural posture.
This is a
and
commercial lease.
That's
right?
correct.
And the obligation to pay rent pursuant to a commercial lease is an independent covenant. It runs with the lease. So I don't understand how you can be relieved by paying that use and occupancy under the circumstances that you have here, absent some express provision in the lease. And I don't know that there is such.
I'm sorry, this is not about being relieved of the obligation. It is that determination of the amount of rent that's owed and the viability of any defense is subject to adjudication at a later time, either in this case or in a separate non-payment of rent case. What we have before the court is simply.
But under what, I am trying to understand under what case law, again, you are permitted to wait until everything gets litigated where there is an order to pay rent.
That's not what the order says, though, Your Honor. The order says that if you want the Yellowstone to continue, you have to make up that
Are you
non-payment.
suggesting that that the obligation to pay rent didn't exist already? So that was an ongoing obligation. The fact that you're in court does not alleviate you of your contractual obligation.
Subject to defenses, subject to an appropriate.
That's not what the
procedural
storage
posture.
lease said. It said that there was no set-off or deduction whatsoever. That it says in Article 3A that the tenant was required to pay rent on the first day of the month without any set-off. So how does that affect your argument? Isn't it fatal to your argument?
No, it isn't in any respect, because the issue of the payment of rent was not before the court in this particular
So
instance.
you're
This is just
saying
a
that it's
condition.
because there wasn't a non-payment action?
I'm saying because this was a condition for the continuance of the Yellowstone. There's no
It
default.
sounds like you're saying that if there was a non-payment action, you would have had to pay.
Well, there would have to be
But
an
because this
adjudication.
was use and occupancy that you were ordered by the court in order to get the Yellowstone, which you got,
That wasn't until later, Your Honor. That was a condition for the continuance of the Yellowstone injunction. When we couldn't meet that condition, we surrendered possession of the leasehold to the landlord. At this point, there has to be an opportunity for there to be, whether it's successful or not. We're not talking about the viability or the defense to it now.
we
in this
understand
particular
your
posture.
argument. Thank you very much.
Thank you.
Your Honors, I'll just leave you
Just a
with.
moment, please.
Oh, sure. I'll just leave you with this. The case was brought by them in 2018, and other than just objecting to the Yellowstone conditions, they've taken absolutely no steps to prosecute their case. So I think the argument that counsel is making holds no water. Thank you, Your Honors.
Thank you. Thank you both. SM, an infant versus Madura. You may begin.
Thank you, Your Honor, and good afternoon. May it please the court. My name is Guy DeRosier, Wilson Elser, for the appellants in this case. Now, this case arises from a fatal motor vehicle accident. The decedent, Jennifer Paracella, who was driving a van loaded with fresh produce, rear-ended a flatbed truck on the Major Deegan Expressway. There were 2 minor passengers aboard the van at the time of the accident, both of whom are plaintiffs in this case, as well as the decedent's brother, non-party Michael Paracella. The accident gave rise to a number of lawsuits. In a 2019 action, which was commenced by the same
Counsel,
plaintiffs.
in this particular case, the real question is about whether or not the decedent was an employee of the defendants. Is that right? I mean, is that what this boils down to?
Well, there were 3 theories of liability that were asserted in the complaint. One was based on VTL 388. The second one was on respondeat superior, and the third one was on alter ego liability. And our argument essentially was to address the VTL 388 action on the basis of CPLR 3211A1, and we submitted the vehicle registration, which conclusively showed that the vehicle was registered in the name of Dan Madura, not my client, John Madura. So that, I think, takes care of that particular theory of liability, which would warrant dismissal on the law under A1. Now, with respect to the other 2, which includes the employment allegation and the alter ego allegation, our contention is that these allegations, as stated in the complaint, were insufficient. They were insufficiently pleaded. They were not backed up by any factual.
But how have you pled that by documentary evidence? I mean, you've asked for 3211A1 as well as A7, but how do you substantiate that claim based on the documentary evidence you've submitted?
Well, again, I think the documentary evidence gets us all the way there with respect to VTL 388. With respect to the remaining claims, including the employment allegation as well as the alter ego allegation.
Counsel, pertaining to the employment claims, there were certain tax records and payroll information that was submitted, but how, I'm going to just ask you the very specific question because I think this is the point. Does that information that was provided, does that dispel that this decedent could not have been an off-the-books employee? And if the person was an off-the-books employee, would you be liable?
Well, again, the basis for our claim was mostly A7 for this, and we're not, let me be clear, if the court agrees that the allegations in the complaint were insufficient, the remedy is dismissal, not on the merits, but simply.
Well, let's assume we don't think that. So, and now answer my colleague's question.
Well, the documentary evidence, we did submit evidentiary facts in support of the claim that there were not employees, but obviously proving a negative is difficult. We did submit.
Proving a negative means that you need to go to trial, doesn't it, on this issue? Isn't this going to be a question of fact? How are what you have are records of employment. Okay, those who were employed, but the argument is that these people, this woman was off the books, and everything her brother testifies to about the way they worked was off the book. Do you have anything to prove the negative,
the
as you
fact
just
that-
said?
Yeah.
Well, let me say this about the brothers, because we were the ones who submitted the brothers' EBT testimony, and I think this is an important fact because I don't think the court, the Supreme Court, maybe did not fully understand why we had submitted that evidence. But one month after this complaint was filed in this particular case, an attorney from Weitz in Luxembourg actually deposed the brother in another lawsuit and asked him specifically during this deposition, which is in part why we submitted this as part of our evidence. In addition to Dan Madura, who's a brother of my client, John Madura, do you know the names of any of his brothers whose farms you had previously worked on? And again, Michael Paracella was a passenger in this vehicle. His answer was, yes, I did work with Chris and Ron. All of the evidence here and the testimony of Michael Paracella during his deposition, which is part of the evidentiary facts that we submitted as part of our motion, show that the decedent and Michael Paracella were employed by 3 of the Madura brothers, Ron, Chris, and Dan. There was never any mention during that deposition of the decedent or Michael Paracella being employed on the books or off the books by John Madura or his companies.
But the brother, I think, in that testimony said that he couldn't remember the names of all of the Madura brothers. He said that when he worked there, I think this was the testimony, that he would return and give the money to whichever one was there.
And what he described seemed to me a separate but joint family business of farming, and different farms perhaps produce different types of products, and they collected everything and drove down to the city for the farmers markets, because obviously this woman was connected to one of these brothers, seeing as she was driving their car with their products, right?
Well, again, these factual allegations come from plaintiff's description of Michael Paracella's testimony. They don't come from the complaint itself. You could look at the complaint, you won't find any of these allegations in here, which is partly why we moved on the basis of A7. And in fact, the only factual support in the complaint with respect to these alter ego allegations is that the defendants all owned and operated farms, and that they all delivered and sold their farm products in farmers markets.
So does your client state or testify anywhere that he had nothing to do with the produce that was delivered by the decedent and her brother?
Well, there's specific testimony on that from Michael Paracella's EBT for the what they got that morning was produce, and this is mentioned in our brief. I could get the exact page site, but he testified specifically that the produce came from the farm of, first of all, he picked up the van at Dan Madura's farm, and that the produce included produce from his farm as well as the two other brothers, Chris and Ron.
Thank you.
Thank you, Ron.
Good afternoon. May it please the court. Meredith Abrams by Whites and Luxembourg on behalf of the plaintiff respondents. I think you said it exactly right, Your Honor, when you said that the real question is whether the decedent was an employee of defendants. And as Supreme Court properly found, that is a question of fact. That should not be resolved on a pre-motion.
Is there any allegation anywhere that the sister was paid
By
anyone? I mean, I found in the record at 126 that when the brother Michael was asked, you testified to something earlier, either your sister or one of the brothers would arrange payments at the end of the day or before a work day. What did you mean by that? That what? I'm sorry, your sister or one of the brothers would arrange for the payments, assuming the salary, the pay that somebody would get for days' work. Do you recall testifying to that? Yes. So is there any allegation anywhere that the sister actually was paid by the brothers instead of somebody else, or not at all?
I don't think there's a specific allegation of which individual paid the decedent. The allegation is that the brothers were operating the farm stands, as you said, jointly, that they were growing this produce, they were loading it onto one common van, selling it, and then consolidating the cash into a single cash box, bringing it back to the farms, and that she was being paid in cash by the brothers.
Is that an actual allegation, or did someone testify to that?
The complaint states that the decedent was an employee of the brothers, and Michael Paracella testified that they were paid in cash each time that they worked for them. So
they or he?
I believe he testified that he was paid in cash. I'm not sure if there's testimony as to how Jennifer Paracella was paid, but at best, it would be an open question of fact as to whether she was paid in cash or whether she was paid, credit card, whatever it is.
What about your claim for the alter ego? How do you substantiate that?
Your Honor, the complaint alleges that the brothers, by virtue of their operation of the farms, the farmers market stands, kiosks and deliveries to other markets, were alter egos of each other. As you said, that they were.
You don't just state that. You have to show that there's allegations of complete dominion over a corporation or some other entity.
Yes,
which
Your
was
Honor.
used to commit the wrong. I don't know that the brother testified clearly enough to be able to determine specifically which brother exerted dominion and control over the corporation, or whether there was one.
Yes, you're right that he testified that he worked for the Madura brothers. He also testified that he worked for Madura's sisters, that he couldn't remember all of the names of all of the people he testified to. Some of the documents that my opponent submitted included land deeds such that John Madura satisfied the mortgage of C. Madura Farm Corp. And Caroline Madura could well be a Madura sister. This is exactly the kind of issue that needs to be fleshed out.
But isn't that speculative? I mean, wouldn't you need to have a little bit more facts for this particular cause of action?
Well, that's exactly the kind of issue that could be fleshed out through further discovery rather than resolved, pre-discovery on a motion to dismiss. Additionally, Michael Paracella testified that the van took stops at the Union Square Green Market, which appellants state that they sold their produce at. He says, I sold my produce at the Union Square Green Market. So it would make sense that they were all on the same van.
But the fact that, so I'm going to play devil's advocate now, the fact that they all put all of their produce into the same van in order to get into Manhattan to the farmer's market, and they all sold their produce and their whatever it is they grew at the farmer's market, doesn't mean that they dispensed with all corporate formalities, that they were so intertwined that one could be said to be the other. There's no allegations with respect to that. The address that they all utilize for their corporation, is it the same? Do they have officers to their separate companies, and are they all the same? That kind of thing. There were no specific allegations that we would typically see in an alter ego claim.
Yes, Your Honor. And I'd like to compare the allegations in our complaint to some of the complaints that appellant brought up in his brief of alter ego allegations that were insufficient. So, for example, he brought up WBF Telecom, in which there was a record from the plaintiff in a
Yeah, but I need you to tell me what's in here on your case that would justify maintaining an alter ego claim on these bare bone, can she answer?
May I respond?
On these bare bone allegations.
Or if you have a case that is similar to what you have here.
Yes, Your Honor. I would say first that the complaint does specifically describe the activities that they undertook together, and that on a pre-motion answer to dismiss, it must be taken as true. I would also turn to the case of Kostianikov versus HFC Capital Group. This was a recent case out of this department in which an attorney's affirmation based on information and belief was sufficient to support claims of alter ego liability. And in deciding that a motion to dismiss should not be granted, this court said these circumstances reflect the very principles underlying alter ego liability, and it's fact-laden nature. And I think that's at the heart of this case. This is a fact-intensive issue that cannot be resolved on a pre-answer motion to dismiss. Thank you.
Thank you.
So
Just
counsel,
just a moment.
so counsel, is there a distinction between operating in an alter ego capacity and operating as a joint venture?
Well, there's no allegation of joint venture, first of all, in here. It's an alter ego allegation. I was just going to get to that. My understanding of alter ego liability has to do with the relationship between a corporation and its shareholders. I've never heard of it applied between siblings in the same family, and I'm not quite sure that the complaint explains exactly how that theory would
Can
work.
you distinguish the Konstantikov, I'm pronouncing it right, case the council referred to?
Yes, absolutely. And I addressed that in our reply brief. The Kostanikov, I'm not sure I'm pronouncing it correctly, was, first of all, a much more fulsome complaint. And secondly, in opposition to the complaint, instead of standing on their pleading, there was an actual affidavit filed by the non-moving party that essentially explained in detail her personal knowledge, I believe, of the facts that were at issue. And so it's a completely different case.
Well, counsel, I mean, we are talking about a pre-answer motion to dismiss here. Wouldn't the brother wouldn't have all of the information that you're expecting him to have for this? Wouldn't it make more sense to maybe revisit this issue after discovery?
Well, let me answer that question maybe with a comment that I made initially. If it's a dismissal under A7, it's not on the merits and has limited preclusive effect. And the fact here is that the plaintiff had every right to stand on her complaint in the face of an A7 challenge and say our pleadings are sufficient. But if that is not correct, and I would submit that the pleading in this case, particularly on the alter ego and also on the bare bones employment allegations, were insufficient, then the remedy is to dismiss the action, again, with limited preclusive effect. And if they can come up with something better, then they're free to try again and do it the proper way. But it shouldn't be deemed sufficient to open the doors wide to discovery if the complaint ab initio is deficient. Thank you, Your Honors.
Thank you. Thank you both. Bucci versus the City of New York. Oh, I'm sorry. I'm sorry. There's the Rosario case. I think I gave Rosario 2 minutes. Thanks. Just let's wait a minute for the.
Good afternoon. I'm Stuart Diamond. I'm here on behalf of Ms. Rosario. I will be exceedingly brief. Defendants failed to satisfy their burden on summary judgment on the issue of a latent defect because, by their own admission, there was a 5-foot space below this floor. They offered absolutely no evidence that they could not have, which is basically their argument, that they could not have inspected the underside of the floor by getting under that 5-foot space or just looking under that 5-foot space. They also admitted that they never lifted the 2 mats, which is clearly not a reasonable.
There was no certificate of occupancy for the premises either. Isn't that right? So there was no inspection for the premises at all,
They had
at least for that outside area.
They had their own inspection by an inspector when they purchased the property.
But there was no certificate of occupancy
Yes.
for that.
Correct.
And the
the deck.
inspection, I'm sorry,
I'm sorry.
and the inspection report was never produced, right?
Correct. And not only was it not produced, the defendant testified his deposition that he had it. We demanded it at the outset of the litigation. It was never produced. They say that it was somehow our burden, and maybe at trial it is our burden, but on summary judgment it was their burden to show that the inspection report didn't provide them with actual notice. On the issue of constructive notice, and they have to prevail on each one of these points. On constructive notice, their testimony was vague. The one of the 2 defendants testified. He didn't say when, if ever, he had actually inspected the deck. And then, even if they get past latent defect and constructive notice and actual notice, we think that there's a triable issue of fact on res ipsa loquitur. The only element that they contest is exclusive control. And their argument is that they only owned it for 2 months before the
It was
accident.
vacant.
It was vacant, but they owned it for 2 months before the accident. They cited a couple of Second Department cases. We cited this court's decision in Mejia, which said where in certain same circumstances there's a claim of negligent maintenance, it doesn't matter that you didn't own the property when the defect arose.
Thank you.
Thank you.
Now, Bucci versus the City of New York.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant.
Just a minute,
I'm
Mr.
sorry.
Isaacs.
I'm sorry, Your Honor.
Thank you.
Thank you. My name is Brian Isaac. I represent the plaintiff appellant cross-respondent. Let me talk to you about the 240 and the 241-6 claim first, if I can. Facts are not really substantially in dispute. The plaintiff is working at on an elevation-related device. The strand that gets stuck, that is struck by the driver, hits him in the face. A couple of the questions are, is this a 240 sub 1 case? I would suggest to the court that Lind, your decision in Lind against Tishman Construction Corp. is directly on point, not really refuted by any of my adversaries. 180 AD 3D 505. In Lind, the plaintiff was operating a device that was elevated, and because he lost control of it due to his failure to engage the brake properly, It careened down, struck an object, and the term you used was ricocheted.
Right,
Ricocheted within there.
But that's the distinguishing factor between the Lynn case and the facts here. There's really no allegation that this particular plaintiff ricocheted, was knocked around. It's really that the cable hit him, right?
But I don't think there's a functional difference between, say, a ricochet, which strikes you in the face, or getting hit in the face with a particular device. And even if there is,
But here the cable struck him because of kinetic force as opposed to a gravity-related force.
yeah, you could say that, except, again, I have a second case that I'd like to just bring up to your attention, and it's an older case, but still a good case. It's Dominguez against Lafayette Boynton. It's a 240 AD 2nd 310. It's an old case, First Department, 1997.
Well, that one talks about lateral force.
Correct.
Is that what you're talking about?
Yes, and what happened in the case, apropos to what both justices have said to me, is in that case, the plaintiff was on a perfectly good scaffold. There was nothing wrong with it. And it was a moving scaffold that would move from left to right or right to left. The problem was that there was an air conditioning unit on the exterior wall where they were working. So what happened was the plaintiff and his coworker jerry-rigged the system to get around it. They put their feet on the wall, pushed out, and went around, and they were successful 3 or 4 times. The fourth or fifth time, they weren't successful, and the plaintiff was injured when his knee struck the air conditioning unit. That is a kinetic force case. I understand.
But I don't know that the court said that. I think the court said it was an accident, was gravity-related.
Yes, it was gravity-related because they were at an elevation, but the force, I'm talking about if you combine Lynn and you combine it with Dominguez, you have both elements, right?
Except that in this case, in Lynn, the labor law violation was in not either erecting a scaffold that could maneuver around the level of these air conditioning units so that they would not have to kick off the building in order to get the scaffold around it. That was not this situation. Here, there's nothing wrong with the bucket, the lift. There's nothing wrong with its positioning. The only problem is that this truck goes under just shy of the ceiling and snags on the cord. And it doesn't drop on him, like the clip doesn't fall from above him and hit him in the face. It slingshots into his head.
Correct. And again,
So that's not a gravity-related event.
if I only had Lynn, I understand the difference, but I'm trying to combine, doesn't seem like I'm being too successful, but
Do you have another case other than the one the Lind and the other that you mentioned, where you suggest lateral force, but the court said it was gravity-related?
Well, the other case that came down, which you know from reading the briefs, is post-Lynn, the second department decided the Johnson case. It's a 207 AD 3-day. And again, they're using the term ricochet. So the reason I'm using the term ricochet is I know how literal you are with the decisions that you have, because like the rest of my colleagues, we read them all the time. Ricocheting is not a downward force. It's a straight-out lateral force. And so if you take those two cases, someone is at an elevation-related level, you combine Dominguez and you combine Lynn, you have a lateral force, which was okayed by this court based on my review of the Dominguez case, and you have a ricocheting effect when someone's up on a device. To me, that's a 240 sub 1
Except
case.
we don't have any ricocheting here.
It's not
There's no ricocheting. He's in the basket. The basket is solid. He's hit. It's like being on solid ground. The basket does what it's supposed to do. He doesn't go anywhere.
Right, but the basket did what it was supposed to do in Lind also. I understand your point. I'm just saying.
The basket was a little different in Lind because the force of gravity caused it to bounce all around, which is not here, which seems to be what the court relied on there, that we don't have here. Anyway, thank you.
Thank you.
Good afternoon, Your Honors. Jeffrey Gasparo, Coffee Modica, White Plains, New York. I represent Joel Encarnacion, who was the driver of the truck involved in this incident, Henry Haas, Inc., and Intercontinental Trust Brokerage Corp. Your Honors, the Supreme Court erred in granting the plaintiff summary judgment on the issue of liability against my clients under a negligence per se theory. For the doctrine,
Did he stop at the stop sign?
Um,
He said no, but the video said yes.
I 2 points on that. He does go through the stop sign.
So
Vehicle-
on negligence, you're not questioning liability?
No, Judge, I believe that negligence per se doesn't apply
I
at
didn't
all.
say negligence per se.
And also, I believe he had no duty in this case. But let me explain why. And I want to
No
make sure I
duty
get
to
to your
stop
point
at the
about
stop sign?
the Vehicle and Traffic Law 1172A doesn't say a driver has to stop at a stop sign. It says when there's a stop sign, you have to stop at this is from the statute, stop line. Or if there is no stop line, then at the point nearest where the traffic intersects the intersection.
But the video doesn't show him stopping.
Well,
At all.
he wouldn't be required to stop where the stop
So
sign
you're
is.
saying now that when there's a stop sign, a driver does not have to stop at all? At all is what
Not
I'm
at the
asking you, not
not at the
stopping at a
sign.
line.
Not at the sign. They have
He
to
did
stop
not
at a line.
stop at all.
Correct.
Okay.
I'll concede that he didn't stop, so I
good.
can make my other
Good,
points.
you have no choice, seeing as there's a video showing that he didn't stop.
I was hoping you'd get to that point.
Okay, so Vehicle and Traffic Law 1172, 1142, these are stop sign statutes. In order for negligence per se to apply, the plaintiff has to be within the class of persons who are intended to be protected by those statutes. Stop sign statutes, vehicle and traffic law statutes are intended to protect the class of persons or other drivers.
So you're saying, as for negligence per se, since the plaintiff was in a basket up above, he was not within the consideration or the zone that this statute considers. However, for just negligence, that's a different story.
So
Is
now
that right?
You have my point exactly on negligence per se. I'll move on to negligence. The case law says, I cite Mid-State Mutual Insurance, Guzman, Vicinius, these are all in my brief. A vehicle driver is not required to be on the lookout for wires extending across a street lower.
That's not the question.
Except perhaps on a construction site
Well, this was not.
where you see a lift right in front of you and a worker. Counsel, this argument just, is on the cusp of ridiculous because it does not at all appreciate good old common sense, which is kind of what the VTL is based on.
Judge, this was not a construction site.
I'll
this
add
was
something
utility
else here.
installation, yes.
Even if there was not a construction site, there was a stop sign. Are you saying that because the statute doesn't put this individual within the particular zone, that he had no responsibility to follow it? He had no responsibility to stop?
He had to act reasonably under the circumstances.
Reasonably under the circumstances would be to stop and look and then proceed.
Just so I can explain, at the moment of the
It
accident,
was in an intersection. Reasonably under the circumstances in any intersection would be to stop and look and proceed. He didn't look at all. Had he taken a moment to look, he probably would have seen what my colleague just suggested. The cable, the machine that put him up in the basket.
I'll
I think
wait
you'll
for my
leave it
rebuttal.
there.
Thank you, Judge.
Yeah, which I don't really think you have.
Good afternoon, Your Honors. Charlene McLaughlin with Calistry McLaughlin for Appellant Third-Party Defendant Verizon New York. My issue is very narrow in this case on appeal. Verizon is plaintiff's employer at the time of the accident, and we were doing work at the market pursuant to a notice sent to the city to install fiber optic cable pursuant.
was
Except
the
you
Verizon-
didn't follow the schedule. You didn't conduct you didn't perform it in the manner in which it had been described to be performed. So why should you be let out?
Well, it's not a matter of whether we should be let out or let in, but whether we should be indemnifying the city pursuant to the statute. And there's no case law whatsoever that says Public Service Law Section 228 requires us to automatically indemnify the landlord without any further action taken by the landlord requesting same. And there was none done in this case. So whether or not we abided by the schedule really has no implication as to whether we have to statutorily indemnify the city based only on a statute language alone. And there's no case law that
So you're saying there should be first a finding of negligence before this issue is even reached?
I think there should have been a contract engaged by the city and Verizon that allows for indemnification for this specific claim, because the statute says the landlord may require the cable television service to enter into indemnification agreement. It doesn't say the cable must indemnify the city, correct. What the contract does say, or the documents does say, is that Verizon will repair any damage to the building caused by Verizon's actions. Nothing against Verizon will indemnify for bodily injury claims related to the work that we are doing there.
Thank you.
Thank you very much.
May it please the court, my name is Stephen DeServi. I'm an attorney with the law offices of Abrams, Gorlick, Friedman, and Jacobson, and I represent the respondents, the City of New York, and Hunts Point Market. Given the court's questions, it is clear that the court understands the issues involved, so I'd like to take just a few minutes to differentiate the cases cited by the plaintiff's counsel, the appellant. The Lind case, the plaintiff lost control of his vehicle while descending a ramp, clearly the act of gravity. In the Dominguez case, the actual scaffolding wasn't the proper device because it was swinging and it wasn't erected properly because it didn't allow the workers to get around an air conditioner. The Johnson case, it was an elevator shaft that was turned into a garbage chute, and the workers were throwing the bricks down the chute, and one ricocheted and hit the plaintiff, clearly an act of gravity. If we accept plaintiff's counsel's reading of the law, it would put labor law in a realm where every peril that occurs off the ground is covered under the labor law. The fact remains, gravity had no part in this accident. It was a result of a horizontal kinetic force.
What about Labor Law 241 sub 6?
Labor Law 241 sub 6 was inapplicable because the plaintiff testified himself. Well, let me take a step back. The plaintiff was actually the flag person who was responsible under 241 sub 6, and he was performing those functions. The plaintiff testified himself that he decided to stop because it was no longer needed. The construction was over, the wire was in its final resting position. The wire failed not because it was low when it was being installed, it failed because it was installed in the wrong location. This wire was a ticking time bomb that was going to get hit at some point at some time, and it happened right after they finished.
Could you address the public service law?
Absolutely, Your Honor. And I'd like to correct sort of a misstatement that was made earlier. There's a claim that there's no contract here, and that's wrong. There was a proposal sent by Verizon to Hunts Point in the city of New York, which incorporated the public service law verbatim. Hence, there's an agreement or a proposal which incorporates its terms.
The proposal and a contract are two different things. Is it a contract or is it a proposal?
Well, it's called a proposal, but it is a contract in the legal sense that there was a meeting of the minds, meaning that there was an offer.
Signed meeting of the minds?
It doesn't have to be signed, Your Honor. The case of Flores versus the Lower East Side Management, which was a case that came out of this department and was decided by the Court of Appeals. The Court of Appeals specifically stated that when a party performs under a document, whether that document was signed or not is not necessary. Their performance is the actual signature.
But I want you to address your adversary's argument that the statute says that it may require, not it shall require. So why should the court have granted summary judgment slam dunk? Why?
The statute does say may required, and the landlord is requiring that they indemnify them, and the demand came from the third party.
But wait, the fact may require, right? Isn't there an issue there? Does that, so are you saying that that language may require solely falls on whether the landlord decides that it should be required? That's all that it takes?
That's correct, Your Honor, and if you look at the legislative history of the statute.
What case law says that? What case has interpreted that public service law section 288 to say 228 to say that?
Admittedly, there's not a single case on any of this. So this is an issue of first impression, but I leave you with this, Your Honor. If that is the reading of it, then the indemnification provision has no effect. It applies to nothing. So why would the legislature put that in the statute if May was going to be given this meaning where it's not going to happen?
So you started to say, and I cut you off and asked you what case law, you started to say in the legislative intent. Tell me.
So the legislative history is quite clear. It says that there's this imbalance between these companies, Verizon being one of them, and landlords, because these companies are given a license to enter against the landlord's will. Landlord doesn't have to consent. The landlord doesn't even have to agree to it. They get this license to enter at their will, and in exchange for it, there are certain rights that are given to the landlord. One is the landlord can stop the work if it's unsafe to the property. The landlord cannot be charged for the work, and the third is that the landlord could request indemnity. And this isn't like the typical construction where a contract goes back and forth. This is Verizon walking in and saying, these are our terms. And we actually objected to them, as shown in the record, and we were told, so sorry. So under that fact pattern, I don't think the legislature intended this to be a non-right.
Got it.
Thank you.
Thank you. Just a minute again, please. Thank you.
Thank you, Your Honors. If I can just add one more point on the common law negligence claim as well. I know you know this as well. This driver got into an accident 15 to 20 minutes before in the same exact area with the same people. So the notion that it's unforeseeable or that he's not an intended beneficiary of the statute or the common law duty doesn't make any sense legally, and it certainly doesn't make any sense factually since he had this accident. Now, there is a dispute about the accident. He says that the workers lowered the strand so he could go through. The workers said he snagged it, but it didn't have any slack on it. If the workers lowered it, it's even worse because then he knows they're there. With respect to the 241-6 claim, I'm not going to go over my time. I think it's a perfect claim based on what Mr. Clark said, and I just want to give you the page references. 702 to 705, 715, and his reports on 1065-1074. The argument that plaintiff was a flagger is not accurate. He did do some flagging, but at the time, he wasn't doing it. And I think the regulation applies in that circumstance. Thank you.
Thank you. Counsel, I have to say again, I don't think there's a cross appeal. I think there's a cross claim here, which does not entitle you to argument time.
Judge, I believe we have a cross appeal.
Okay, I hope so, because if I find that there isn't one,
There is no cross.
I'll have to get in touch with you. Why don't you proceed? I'll give you 1 minute.
Judge, when the driver came through, the first time Mr. Isaac referred to that as an accident, it wasn't an accident. There were workers there with flags and cones. The strand was snagged. They either raised it or lowered it, and he came through. When they came back, this is the plaintiff's own testimony at 335 of the record, they're down away from the opening where the driver came through. The strand, according to the plaintiff, had been jacked banjo tight, that's 328 from the record. Multiple clamps had been passed along. So when Mr. Encarnacion comes back through the second time when the accident occurs, there's no flagger, there's no cones.
So there's the first accident, it's lowered for him. 20 minutes later, or however long it is, he totally has forgotten that there was any issue with a cable or anything. So he doesn't even stop for the stop sign, and he goes right through. And is that what you're saying, that we should, because of that,
Judge,
we don't consider anything here?
when he came back through 1430 and 1493 of the record, the strand had been installed in its final position. It wasn't draping. The workers had moved down to continue the project. It is where they intended to leave it. The construction in that location had ended. At a minimum, there's an issue of fact on duty and proximate cause.
Thank you.
Thank you, Judge.
There's no cross appeal.
No, there's no cross. That's okay. Well,
I have a very short time. I just want to address my adversary's argument about the imbalance of power. Verizon doesn't show up on the property day one and say, we're going to do this. We provide notice to the property that we're going to do work at the property and cite the statute so they know what their rights are if they choose to take advantage
Were
of
you
that.
scheduled to work indoors that day as opposed to outdoors?
We were scheduled to work, I believe we were scheduled to work outdoors, but in a different, I could be wrong. We were scheduled to work indoors that day. There was a change that day.
Thank you.
Thank you.
People of the state of New York versus Anucci. And just wait till I put the lights on.
Which, in a pinch, I'll do. I don't care.
Thank you, counsel. Thank you, counsel.
Thank you, Your Honors. Philip Levitz for the appellant. This court should reverse Supreme Court's grant of Maniscalco's petition for either of two independent reasons. First, it's undisputed that Supreme Court erred in counting hearing deadlines from the date of parole warrant issuance instead of the date of parole warrant execution. And second, Maniscalco's preliminary parole.
Between the parole warrant issuance date and the date that you lodged it. That happened the same date, correct?
In this particular case, Mr. Maniscalco says that happened on the same date.
What do you say?
There isn't a clear record as to when that happened, but that's not the relevant question. The relevant question
That is the relevant question.
it's not under this court's existing precedent in the Morant case, which governs
That's
here.
the one that I'm asking.
Uh-huh.
When was it lodged?
It's not clear from the record. I think it was.
Doesn't docs have proof? Whenever a warrant is dropped, lodged, whatever verbiage you want to use, there is a recording, a record of that fact. So you're standing there and telling me you don't know what day docs received this warrant at their facility. Is that what you're saying?
I don't represent the city Department of Correction. I represent the state. Okay, so
Are you saying
my
you
client
didn't
has
look to see when this warrant was dropped on the facility?
It's not relevant to this case, and it's not
Counsel,
a record that the petitioner.
Counsel,
Yes.
I need you to understand
Yes.
that when the court asks a question, that's what's relevant.
And my answer
You
is that-
answer it.
Right. So my answer is the petitioner is the one who brought this case. It was his burden to present whatever evidence was necessary to prove that the hearing here was untimely. The hearing was not untimely.
Let me just ask
And
this
the reason
question.
for that,
What happened on June 17th, 2022? What happened that day?
there was a parole warrant that was issued for to revoke the parole of Mr.
Was there a
Maniscalco.
charge sheet that also reflected that that warrant was enforced on that day?
There's a reference in that.
Is there a charge sheet
It-
that
it-
says, maybe at record
36.
36?
There is a document in the record that says that the warrant was enforced on that day, but that's not the relevant question. Again, please look at the Morant case
Counsel,
that you're.
let me just make clear.
Yes,
If this court asks you a question,
I'm happy to answer.
please
it. Yes.
do not tell us that it's not the relevant question. Just answer the question. Now, the question was with regard to June 17th. Was that warrant issued to docs where this individual was being held? Yes or no?
I don't know the answer to that question. That is a question that I would.
You don't
ask
know the
other
answer?
side.
Okay.
Okay, that's correct. So
What
if I-
bearing does the charge sheet found in the record at 36, what bearing does the language date warrant enforced 6/17/2022 have?
It has no
relative to-
bearing under this
I
court's
didn't
decision
finish.
in Morant.
I didn't finish.
Okay, I'm sorry.
Relative to your argument.
it has no relevance to my argument. In any event, if you didn't agree with the argument that we've made based on the Rant case, which is binding on this court, there's a separate independent reason that the Supreme Court erred here, and that is that the statute is very clear that there are two alternative ways to count the deadlines here, or the deadline for the preliminary hearing here.
Argument Supreme Court.
We responded to the arguments.
Concede, whether directly or indirectly, that the 17th was the date that the warrant was executed?
No, absolutely not. It wasn't addressed. It wasn't addressed.
You make the argument that it was not, that it was another date. The argument that you're making now that it was the 22nd.
That argument wasn't squarely presented below. It doesn't matter because it's a purely okay, but it's a purely legal argument. So it's an argument that this court can. I'm sorry.
It's a preservation issue.
There is a preservation question that Mr. Maniscalco has raised, and under this court's established.
And it's your problem, right? So did you preserve it? Tell me how.
I think it's preserved because it's subsumed within the larger statutory argument that we made below. But in any event, it doesn't matter because this court's precedent again is clear. And the other side.
You know something, counsel?
Yes.
How about giving a straight answer to straight questions? These are really simple questions.
Right. I'm trying to direct the court to what I think is.
How about not directing us, and how about allowing us to direct you?
Sure. I'm happy to answer whatever questions the court has. So I'm sorry.
Because I've asked you a million times already. Was the warrant lodged on the 17th? And I still don't have.
I don't know the answer. I would suggest that you ask Mr. Maniscalco. It may have been.
What do you know, counsel?
I do know that
Was Mr. Maniscalco the one who lodged his own warrant? I don't understand. Why would we ask him? We're asking you.
Okay. What?
So isn't the fact that the answer to that question doesn't bode well for you? So you want us to believe that the only date that counts is the one that you picked that counts, which is the 22nd, the one that the defendant was personally sued.
It's not what I picked. It's what this court picked in the binding Morant decision. But in any event, again, it doesn't. There's a separate independent basis that I want to make sure the court understands, which is that there are two alternatives here. You can count from the execution date, to which all of these questions are relevant, or you can count from the date of the recognizance order to detain. And in this case,
that would render the statute meaningless.
I don't.
If you could start the clock after the recognizance hearing, then the 24-hour time limit for the recognizance hearing has been ignored and wiped out of the statute.
That's not true at all, Your Honor.
That is true.
I don't think so. And the reason for that, there are a couple of reasons for that. One is that the statute requires that the hearing be held within 24 hours as long as the court is open. The recognizance hearing has to be
No,
held
it doesn't say as long as the court is open, in 24 hours or as soon thereafter as the court is open.
Absolutely, Your Honor. I
And
completely
here
agree.
that did not happen for 5 days.
It did happen counting from the correct date of execution, which is the service date. But in any
The
event,
date that you didn't argue below,
again,
which is not preserved, but you're out of time.
Just before that, just to be clear, in Morant, which is from 2006, before this new law,
yes,
that's what you're quoting for us, that you keep saying is binding.
that's
I just
correct.
wanna
But there's
be
been
clear.
no change to the
Thank
relevant
you.
statutory language.
Is that so with this new statute? Okay, thank
absolutely.
you very much, counsel.
Thank you, Your Honor.
You may begin.
Thank you, Your Honors. Good afternoon, Your Honors. Michelle McGrath from the Legal Aid Society on behalf of Mr. Maniscalco.
When was the warrant lodged?
Your Honor, it was lodged on June 17th.
Right, and once that warrant is lodged, he's not going to be released, right?
That's correct, Your Honor.
Okay, from there, presumably, he's supposed to get a bail hearing within 24 hours, right?
Recognizance hearing, yes, Your Honor.
Recognizance hearing.
Yes, yes.
Did that happen?
That did not happen, Your Honor.
Not for 5 days, right?
Correct.
And who is the entity, or what is the entity responsible for scheduling that recognizance hearing? What kind of follow-up is supposed to be given? Is the detainee capable of scheduling his own recognizance hearing?
He is not, Your Honor, and the obligation is, of course, on docs to...
And isn't there some evidence in the record that docs, in fact, attempted to schedule that recognizance hearing about the 16th, about the 17th?
Your Honor, the evidence is that someone sent a note to a court on the 17th. Now, the problem is there's no evidence that anyone reached out to a court on the second day, the third day, or the fourth day.
But someone knew enough to reach out on the 17th because that recognizance hearing hadn't happened within 24 hours.
Correct, and there were courts available in New York City to hear the case, and as the statute is clear, if there's a court open, then docs must attempt to bring the person there.
Would court congestion have any effect on that 24-hour period?
Your Honor, I don't think that's the issue here, and I actually don't think that it ultimately would affect it, because the legislature has been very clear here. There's a 24-hour mandate. There's no sort of good cause or court congestion exception, and the reason for that is the legislature was particularly concerned, in less is more, as they said in their sponsor memo, of limiting the time of incarceration and shortening the time frame for adjudicatory hearings. So what's happening here is the legislature has provided a backstop for the very scenario that has played out here. If there is some reason that docs cannot provide the hearing within 24 hours, that doesn't mean they get now an extension of time that they can hold the accused in custody for longer. They don't get more time to prepare their hearing. And that's functionally what they're asking this court, is that when they have violated the statute—
It was essentially, as my colleague said, wipe out the purpose of this law in the first place, wouldn't it?
Correct, Your Honor. And what this court cannot sanction is an interpretation of this statute that would eviscerate and undermine the express intent of the law, which was to shorten the time frame for hearings.
What's your reading of Morant, which is still good law? What's your reading of Morant within this context?
Yes, Your Honor. So with respect to Morant, I think it's very important to recognize, as courts always do, that a case can only stand for the questions that were presented to it. And in Morant, the question that was presented by my opponents to this court were, quote, whether the parole warrant against petitioner was executed on the date the warrant was lodged, as opposed to the date of its issuance. And the department asserted in Morant, quote, a warrant is executed when it is delivered and lodged at the correctional facility where the parolee is incarcerated. The word service on parolee is nowhere in that argument, because that's not what was at issue in Morant.
And it was lodged on the 17th here, is that right? With docs?
Yes, Your Honor.
That would be consistent with Morant to the extent that it's saying it's when it's lodged on the place where the person is being held.
On the facility, that's correct, Your Honor. And I think, as the court correctly noted, there's since been a new statute, and that statute has further explained what service has further shed further light since Morant has occurred. So a person has to have a recognizance hearing in 24 hours after the execution of the warrant. Now, what respondents have attempted to do is say that recognizance hearing is somehow also the execution of the warrant. What they have said is service of, well, at first they said service of the warrant, but then there's no record.
Which would mean you could hold the individual for 30 days and then finally say that you're having the recognizance here. There would be no way to limit, as the statute intends, the length of time before the recognizance hearing. The whole point here, it seems, with this statute is to shorten the time as quickly as possible, within 24 hours or as soon thereafter, is what it says, I believe, to have that recognizance hearing. But in the way it's read otherwise, there would be no way to keep a record, in other words, of the time when that recognizance hearing would take place.
I think that's correct, Your Honor, and so that's why the legislature said either execution of the warrant or the order to detain at the recognizance hearing, because the legislature foresaw that if we only measure from the order to detain, there could be these lengthy delays. And so that's why we have to give meaning and effect, of course, to every word of a statute. And respondents—
They seem to have attempted through this statute to mirror the requirements in a criminal arrest, that you must be arraigned and see a judge within 24 hours. Same thing. The same purpose is being brought about by this statute.
I think that's correct, Your Honor, particularly in light of the fact that DOCS previously was able to just, at its whim, issue a warrant and hold people for 15 days. The legislature was seeking a check here, and our interpretation is the one that gives full meaning and effect to the legislative purpose here. Thank you.
Thank you.
Thank you, Your Honors. I just want to...
Just a minute,
I'm
please.
sorry.
Counsel, before you start, I want to tell you, we really want to hear everyone's argument. I suggest in the 2 minutes that you have, that if there are questions, you listen to the questions and answer the questions. You will then get to make the argument you want, but please respectfully listen to the questions.
Thank you, Your Honor. I just wanted to underscore a couple of points, and one is Justice Sherman, your point exactly, which is that the Morant case remains good law, and the Morant case is crystal clear that you count from the service date. And if this court wished to revisit that, which we don't think is appropriate, but wished to, the appropriate action in this case, I think, would be to clarify that it's actually the lodging date and make clear what the law actually is here.
Except that when a person is confined, when you have an incarcerated person, the moment you lodge any warrant on that institution, you are basically served. That's the only way to serve you.
So it's a little confusing here because Mr. Maniscalco was already detained on criminal charges in this case.
Precisely.
Right. So that was the existing situation, and it was the same situation in Morant. The question in Morant was, when was he to be considered under the detention authority of the parole violation warrant as well? And what the court said in Morant is, well, that happens when the parole warrant revocation documentation is served on the parolee. And that happened, in this case, slightly later on June 22nd. And that's why we say that you should be counting from June 22nd, and that's exactly how.
Except that in Morant, they didn't have this statute that required a 24-hour recognizance hearing. That's the difference.
But actually,
that dealt with a older statute. That is not the statute we're applying here.
so there have been changes to the statute, but the relevant language of the statute is the definition of parole warrant execution. That is
So
completely
what is the relevance of the 24-hour recognizance? That has no relevance in your mind?
Of course it has relevance. It's very important that you get 24 hours from the
Counsel,
date of
I'm
parole warrant
wondering,
execution to have the hearing.
In the example that we have here, if Mr. Maniscalco was held on criminal charges, this warrant is lodged at corrections. He couldn't bail out on the other criminal charges, right? Because this warrant is lodged. He couldn't. He's in effect being held now on the lodged warrant as well. It's executed. He couldn't leave, even if he was to bail out on the other case.
That's a true statement.
I'm not sure of the answer to that, but the reason that this, I assume the reason this court said in Morant that you look to the service date, which is typically going to be right around the same day. I mean, it's not going to be far off. I think the reason is if you don't count from the service date, then you could have the hearing deadline, if it's so soon, be before the parolee even has the paper served that present the information about what are the charges, the parole charges against that person, and that just doesn't make sense. So the court used service date as a baseline to count from, and that's the binding precedent this court is working with. So I'd urge the court to affirm what was done in that case. And of course, there's the alternative that we spoke about that's completely independent, that you have these two possibilities that were built into the amendments to the statute that were done, which is that you can count from now that this recognizance hearing option is this recognizance hearing requirement was created, now you can count from that recognizance hearing order or from the date of execution. And I think it's worth noting just very quickly that before you had the recognizance hearing order, what the statute says is you count from the date of parole warrant execution. Then you had these amendments to the statute that create the recognizance hearing, and what the legislature did is they said, okay, you can count the preliminary hearing deadline from the date of parole warrant execution, or you can, which was already what the statute said, but now it says, oh, you could also count from this other date that's now relevant, which is the date of the hearing from the parole revocation, I'm sorry, the order from the parole revocation hearing. And either of those is appropriate, and the or in the statute is just clear, and nobody here, neither Supreme Court nor Mr. Maniscalco, has presented any other legitimate reading of the actual text of the statute, which says you can count from one or the other. So I'd urge the court to reverse on that ground, if not on the first.
Thank you. Thank you both.
Thank you, Your Honors.
Cosme versus the City of New York.
Good afternoon, Your Honors. My name is Jason Steinberg. I represent the plaintiff appellant. Thank you for hearing me today. The color photos in this case from 2016 that my clients circled, where we identified the pothole, is on the record 1194. And the photograph circling the trench, excuse me, the photograph where the trench is circled in addition to the pothole on 1209. And then the 2014 Google photograph is on 964, the record. The question of whether or not this hole was in existence 2 years before my client's accident is an issue for the jury. You can't tell from this record or from those photographs that the same exact hole appears in 2014 as it does in 2016. So it is in that respect that the decision should be reversed. The city also put in photographs in their brief in a footnote where you can click a link and you can see very clearly photographs from 2011 all the way up to 2016. You do not see the pothole that my client stepped in at all in 2015, 2014, in those photos, which are actually better than the ones, at least in my opinion, on the record.
But are they in the record, counsel, that we can make reference to them? The missing photos between 2014 and 2016?
Missing photos?
The Google,
There's a link.
the link.
Yeah, that's in the city's brief. It's in a footnote.
Got it.
But you can, I mean, clearly you click on it and it really shows you, in my opinion, I'd like to say that the real reality is a jury should be looking at the photographs and making a determination as to whether the holes existed. And it's so critical in this case because that really was the basis for the decision to say, well, it existed in 2014. That means it wasn't created by their work. So if you're linking the two together, then it's critical that the jury really assess that issue. I can go on and on about this. Wells back, the evidence is they cut a 38-foot trench. The hole is literally right there. It's next to it. They also said that they temporarily fill it, so it's not really complete until it's restored, and it should be done 2 weeks after they make the cut. In this case, 5 months elapse until Nico comes in and restores it.
What do the photographs show vis-a-vis Nico?
I'm sorry?
What do the photographs show vis-a-vis Nico?
Well, the photograph showed that the hole exists when my client stepped in it in 2016 after Nico did the work. We have nothing before that that definitively shows this hole, arguably.
Are there any photographs that show that the hole existed before Nico did its work?
The judge thought there was, but we disagree. A jury should decide that. There are holes. You can see holes in one of the photos, but you can't make the connection between hole in 2014 and hole in 2016. A jury should be doing that. You may think, oh yeah, I see it. Another judge might think, well, I'm not sure I see it. They certainly think it's there. We don't think it's there. It's really for a jury to decide.
What effect does the city's approval of the work from Wellsbach have on?
Well, as a matter of law, that's not sufficient basis. If it caused the condition, just because the city approved the work doesn't necessarily mean you didn't cause the hole. I want to say, they don't have any testimony from the inspector from the city who does this inspection to say, this is what I look for, this is what I do. So it's arguably, he does the inspection, looks at the trench looks fine, but then says, well, that pothole might have been something else. We don't really know that. So I think that's why the court says, yeah, just because the city approves, that doesn't necessarily mean you didn't cause the hole, and therefore you didn't affirmatively establish your entitlement to summary judgment. So with that said, I think I've said enough that needs to be said.
Thank you.
Thank you.
Good afternoon, Your Honors. Janet Zalian for the city. We support the appellant's position that there is an issue of fact here. In particular, Nico makes no reference in their brief to explain why the testimony about the use of a 3-ton vibratory roller, they call it, that as they testify, as their representative testified, would have gone at least partly over that hole because it's compacting the fill in the trench, but it's 48 inches wide. It's wider than the trench. So the other thing that I would point out with regard to the city's approval, the defendants emphasize that their work involved the trench, and the trench is what's being inspected. The day before the accident is the approval of the invoice, but that doesn't say when it was inspected. Does the court have any questions for the city? In that case, we'll rest on a brief.
Is there any expert who supports what you were saying about the impact or import of the, I don't know what you call it, the roller?
Right. Well, that would have been an excellent way for the contractors to make their prima facie case for summary judgment and eliminate issues of fact if there had been such an expert. It is their prima facie case that is absent here. These questions of fact have not been eliminated as is required in summary judgment, of course, viewing the facts most favorably to the non-moving parties. Does the court have any further questions? Thank you, Your Honors.
Thank you.
We'll ask that the order be reversed.
Good afternoon, Your Honors, and may it please the court. Sean Hughes of London Fisher for Respondent Wellsback Electric Corps. As Your Honors have heard, this case is about whether Wellsback created the roadway defect that the plaintiff tripped in. We submit that the motion court correctly decided our summary judgment motion. The motion court had the opportunity to look at the 2014 Google Maps photograph and compare it to the defect circled by the plaintiff.
Isn't that a jury function?
No, Your Honor. I submit that it's obvious on face that, and the judge had the opportunity to, in rendering its decision, sit back, compare the two photos together, and...
So if we look at the two photos and find, gee, one looks different than the other, then what?
Well, certainly on a summary judgment motion, this court has the authority to review all of the facts.
I guess my question goes to our judgment of the photos versus the lower court's judgment of the photos. Those sound like factual issues that should go before a jury, as my colleague alluded.
Your Honor, I still disagree. I believe that the motion court judge could determine whether review and see the photos, whether an issue existed, but I would also point out that apart from the photographs, there was corroborating paperwork to establish that Wellsback properly performed its work at the site. Specifically, within the record, there was the inspections from the Highway Inspection Quality Assurance, HIQA. Those inspections were passed for Wellsback. They correspond with the permits issued to Wellsback governing the area where the accident occurred. And there was no, Ms. Williams from the city testified in her deposition that there was no corrective action notice issued after those inspections were done. Certainly, if there had been an issue with the trench, the city would have issued notice to Wellsback to return to the site and repair. But further, this defect was outside the area of Wellsback's trench. I'm happy. Thank you, Judge.
Good afternoon. Patrick Lawless for the defendant respondent, Nico Asphalt. The court properly dismissed the action against Nico because there's no evidence in this record that Nico launched an instrument of harm. Its contractual duty with Wellsback does not establish a duty to the plaintiff. And the plaintiff has not demonstrated that Nico did anything to make to either create the pothole or exacerbate the condition.
So, counsel, the difference between Nico and Wellsback is that your client provided a before and after picture, is that right?
Right.
Whereas Wellsback provided an after picture?
I believe so, but I don't, again, I think the issue when it comes to Nico is that there's no evidence other than speculation, as Your Honor pointed out to the city, that Nico did anything to exacerbate the condition.
What about the suggestion that this 3-ton roller at least partially went over the pothole?
Again, that's just speculation. There's no expert evidence. There's nothing in this record to say that that would have had any impact on the pothole itself.
What, doesn't the record support the fact that this pothole was adjacent to, very close to, the area that was backfilled by Nico? And is counsel for the city incorrect when she described the roller as being 48 inches wide, and that it would have been impossible to pack down and roll over just the backfilled portion without having some of that roller traverse over the pothole?
Correct, but there's no evidence as to what impact that would have had on the pothole. There's no expert evidence. There's no testimony in this record that that would have done anything to affect the condition of the pothole.
But is that a deficiency on your part?
No, it's
Since your client wants out and you are arguing that the work we did not at all impact that pothole, nothing about backfilling and rolling over it made it any worse. What would have been the harm in having an expert say? I looked at it. There was nothing.
Well, I would say that it's not our burden because we're arguing under Espinal.
Okay.
And I don't believe it was specifically argued below, but this is the law in Espinal. In Espinal, unless there's specific allegations in the complaint about the Espinal exceptions, that all a defendant has to do is show that they are a contractor and that the plaintiff is not subject to that contract. Then it's the burden on the party opposing summary judgment to come forward with evidence that one of the Espinal exceptions apply.
And
so I believe the city is incorrect saying it's our burden to show or to come forward with expert evidence. It would have been theirs to show that we launched an instrument of harm.
Counsel, part of your argument is that and you're relying on photos. Why isn't that photo interpretation subject to jury review?
Well, I believe, and I believe the court correctly found it, because it's not just the photographs, it's also the drawings, it's the inspection records, everything else corroborates what's in those photographs. But again, in order to hold Nico liable, the plaintiff and the parties opposing Nico's motion have to affirmatively show that we either created the condition or made it worse, and there's no evidence in this record to indicate that. Unless you have any further questions, I'll rest on my brief. Thank you.
Just quickly, within my minute, to address counsel's position with respect to the prima facie burden, I direct the court's attention to Terrell versus the City of New York. That's 74 AD 3D 787. Court says, on a summary judgment, comma, a contractor has a prima facie burden of demonstrating that it did not perform any work in the area where the accident occurred and did not create the allegedly defective roadway condition which caused plaintiff's injuries. That's a case, Terrell versus the City of New York. It is second department, that's according to the brief, but it is their burden. And as I think you asked the question, Judge Gonzalez, is there a before and after photo? There is none. There's only the 2014 Google Maps photo. There are some photos from 2016, which I believe were Google, but they're far back. And then there's the November of 2016 photos, which my client circled. If any court has any more questions, I'm just going to take a seat.
Thank you. Thank you all. We are going to take a brief pause to get a little more air in this room. I understand it will create a bit of noise, and we don't want to miss anyone's argument, so just give us a moment.
Especially for me. You know, between the heat. Oh, God, it's hot in here. Don't fall out that window.
Next case is Castillo versus TRM Contracting.
Good afternoon, may it please the court. My name is Peter Ureta. I'm an attorney with O'Connor Red Orlando. We represent TRM Contracting and Neptune South, the owner and general contractor in a labor law 240 case. A minor housekeeping issue here. We came into this case, into this appeal midstream. Prior counsel represented the defendant and made two arguments on the motion to renew. One argument was that there were new facts and the law had changed with respect to the Katia case. We withdraw the argument with respect to the Katia case, and our appeal is essentially on the new facts that were presented by the testimony of Freddie Hernandez in this case.
So two of us at least were on the previous appeal where there was no testimony, although the testimony had been taken, the deposition had been taken. It was not part of the appeal because it had been taken after the appeal was filed. How does that testimony change the result here where the individual Hernandez doesn't, at least from the testimony, doesn't seem that he goes into the room and really surveys the area where the individual was working? At most, what he says is, I told him if he couldn't open the ladder that he should leave. But how does he change the facts that we had at that time with regard to the ability of the worker to open the ladder?
Well, with respect to his testimony that the workers were instructed to work somewhere else if they couldn't work safely in another room, that bears on the issue of a recalcitrant worker defense. The plaintiff, when the motion was made, it was based on plaintiff's testimony that, plaintiff's testimony alone that he did this work, and he had to close his ladder in order to do his work. Also, Mr. Hernandez testified that the ladders were new, they were without defect, so his testimony was significant to that extent.
So he didn't see the area, so what difference does it make that if we take that, what difference does it make that the ladders were new versus old? It really was that he couldn't open the ladder, so he had the ladder in a position that couldn't be opened, and when he reached, the ladder fell. So it wouldn't matter whether it was new or old, would it?
It wouldn't make a substantial difference. Plaintiff had testified that the ladder was rickety and shaky, but he worked in it for 1 minute without incident.
So your best argument is with regard to he was told he should go elsewhere if he couldn't do the work?
Yeah, he could have worked, there were plenty of rooms to work in. He could have worked anywhere else if he needed to do that.
Now, as to this witness, this was somebody who worked for Park, but was no longer working there for quite some time. Why wasn't he available the first time?
I can't answer that. That was
He
a
just
question.
materialized at the right time?
That was the question for Park to answer, and that's outside of this record. There is the record does show a concerted effort to attempt to get his deposition prior to the motion being submitted, and there is a timeline that reflects that the plaintiff's deposition.
Well, you say it's outside of the record, and it's for Park, but your client deposed him, am I right?
Yes.
And your client is the one who says that you couldn't get him.
Well, my client understood him to be an employee of Park the entire time that, until he testified, and had no reason to believe otherwise. Park didn't disclose that he was no longer employed.
I'm trying to understand. You say that Hernandez told the plaintiff and his co-worker that if you cannot open the ladder, then go elsewhere. So are you saying that Mr. Hernandez could not tell when he claims to have observed the room that there was insufficient space to open up a ladder, seeing as these men, the job they had was to tape these floor-to-ceiling windows? So they had to be by the window. He could not see that there were boxes in the way?
Well, plaintiff testified.
No, I'm talking about Mr. Hernandez.
Oh, you're talking about Mr. Hernandez?
Yes.
Oh, man, Mr. Hernandez.
Your witness says, I looked in the room, it was fine, they could have opened up a ladder, but I told them, if they can't open the ladder, go somewhere else. So my question to you is, did Mr. Hernandez not discern that there was not enough room and therefore assign them to another room without the boxes?
Mr. Hernandez was not present at the time that the assignment.
Ah, so he doesn't know.
Yes, Your Honor.
Not to mention, Mr. Hernandez says that he looked at the room, and you can't have it both ways. As my colleague says, either he looked at the room well enough and understood that there was no room to open the ladder and should have told them at that point, go elsewhere. But he didn't really see the room well enough at all to discern anything.
Yeah, but plaintiff saw the room, and plaintiff, by his own
Well, what is
testimony, said he couldn't
the
open
question
it.
is, how does Mr. Hernandez's testimony change our decision, except for what now has come up, I think your last statement, with regard to he should have gone to another room?
And that's it, Your Honor. Thank you.
Good afternoon, Your Honors, and may it please the Court. Michael Peters with the law firm of Siegel and Coonerty for the plaintiff respondent, Noel Castillo. As this Court is aware, this is an appeal from a motion to renew. And on a motion to renew, the movement doesn't get a second bite at the apple. They don't get to re-argue the same things they argued last time. They have to come forward with new facts that were not offered on the prior motion, and those facts must change the prior determination, and perhaps most importantly for this case, the movement must show a reasonable justification for the failure to present such facts on the prior motion. I just want to be very clear here. It's undisputed that Freddie Hernandez was not employed by the third-party defendant at the time of the plaintiff's motion for summary judgment. He had stopped working for the third-party defendant almost a year prior, which means that indisputably, he was a non-party witness who the defendants could have called on the telephone. They could have subpoenaed him to testify. His cell phone number is right on the defendant's accident report. There was nothing stopping the defendants from contacting Mr. Hernandez to submit his testimony in connection with the original motion for summary judgment.
And a little bit of due diligence would have exposed the fact that he was no longer employed.
Well, that's correct. And I should note that Mr. Ureta, who's up here today for the appellants, he represented Park Avenue Paint at the time. I'm sure that if prior counsel had contacted him, I'm sure he would have told the prior counsel, hey, he no longer works for me. You can go contact him. There's no evidence that they even demanded his employment status. There's no evidence that they made any phone calls to the third-party defendant to determine whether he was still employed. They just assumed that they couldn't contact him. So their assumption was wrong.
Is it accurate that there was a bar against contacting Mr. Hernandez?
Well, there was no bar because, again, as he's a non-employee of the third-party defendant.
Was there a bar against contacting employees?
Well, no, there wouldn't be because, according to the Court of Appeals holding in Muriel Siebert versus Intuit, ex parte interviews of adversaries' former employees are not unethical nor legally prohibited. And that's from the Court of Appeals. And it's undisputed here that he was a former employee at the time the motions were filed.
Just beyond that, his testimony added nothing and would not alter the decision prior because he had no personal information.
Well, that's correct. And Freddie Hernandez was not present at the time of the accident. We did have an affidavit from the only other person who was present, and he fully supported the plaintiff's version of events. Although Freddie did at times in his testimony, and he did waffle on this, although he did state that he thought that the ladder could be opened in that area, again, he offers nothing different from what Mr. Samarco did on the first motion, which is, I thought it could be opened, but there's no evidence that he took any measurements. There's no evidence that he attempted to open the ladder in that area. There's no evidence that he made any real attempt to show that other than just a conclusory opinion that he could. And with respect to, and this will be my last point, with respect to the fact that he could have moved on to another room, as this court has held multiple times, an instruction to avoid unsafe work is not a substitute for providing an adequate safety device under the labor law. And that's exactly what they're suggesting here. Hey, this was dangerous work, you should have skipped over it. Well, no, you should have provided him with an adequate safety device in the first instance. That's what the labor law requires. And if there are no other questions, I'll rest on the papers. Thank you.
I do want to make clear to the court that at the time that the motion was filed, as far as the defendant knew, Freddie Hernandez still worked for Park Avenue and had no reason to believe otherwise.
I don't know, as a lawyer, when one is preparing their case and thinking about witnesses, don't they bother to seek out the witness?
Again,
I mean, when you say they had no reason to think otherwise, did they make phone calls? Did they pursue this avenue? You can't just sit there and say, I have no reason to believe it, and you don't try.
yeah, again, Freddie Hernandez is not an employee of TRM or Neptune South. He was an employee of Park Avenue. So TRM and Neptune South had no reason to believe otherwise, that he was no longer employed with Park Avenue. And with respect to the plaintiff's statements, I mean, they were provided with a frame ladder. His coworker safely used it in order to do his work, and they were told there were a bunch of other rooms you could work in that building. If this room, if the room you're working in for whatever reason is not tenable, you can go someplace else. Thank you, Your Honor.
Thank you both. People versus Ricardo Sanchez.
May it please the court, Oliver Lee for the people. Good afternoon, everyone. Your Honor's defense forfeiture stipulation is separate from his judgment of conviction and therefore not challengeable on direct appeal. The plea and sentencing court didn't order or so order forfeiture, and the facts of this case are most analogous to People v. Abruzzese because the court simply confirmed that forfeiture was included in the plea agreement and provided counsel time to discuss the written forfeiture with defendant. Thus, defendant's appeal should be dismissed as not properly before this court. However, even if this court were to address the merits of defendant's appeal, defendant is still procedurally barred from challenging his forfeiture agreement by his valid waiver of the right to appeal. The Court of Appeals has upheld similar waivers, as has this court. Additionally, his waiver of the right to appeal further precludes him challenging his excessive sentence. And, Your Honors, if there are no questions, I would rest on my brief. Thank you.
Chavez versus Grassroots.
Ready? May it please the court, Frederick Allen for the appellant. Your Honor, turning to the lower court decision, the court ruled that somehow we were relying on proof of a maintenance, prior maintenance as the basis for our motion for summary judgment, and that we didn't provide any admissible evidence that we neither created the hazardous condition nor had actual constructive notice of its condition. And there's a lot of focus on the fact that I didn't get an affidavit from the dishwasher. As I think I've stated in my brief, we had contemporaneous evidence from the cook who was there that morning who said there's nothing wrong with the cold.
Also had the dishwasher, who was the person who cleaned the kitchen, was responsible for cleaning that kitchen and any area the night before. And that person was present when the person slipped. Is that right? They were present in the kitchen at the time.
I think the cook testified that the dishwasher had been present.
At the time that the person slipped. Why wouldn't the dishwasher have been in the best position to provide information about the cleaning of the kitchen, which is really the question here that would make this, I mean, and that's consistent with our case law, that you have to have some basis that establishes when the kitchen or when the place was cleaned, some register of the time, the way? There's nothing like that here.
I can give you the factual answer, then I'll respond to
Okay.
the factual answer is I go to my client and say, who's the best witness? And they say, here's the cook. But I don't think,
You know the law.
no, but
Right? So the cook who didn't clean doesn't really help us establish what our precedent, as my colleague just said, we require a witness who can attest to the last time that the area was cleaned. And we have our precedents replete with case law that denies summary judgment where that evidence is not there.
and Your Honor, I'm aware of that, and my answer to that is this case is a little different than those cases in that the cook was in the cold room and says there was nothing there. The co-worker, Mr. Garcia, says there's nothing there.
The problem with that is the cook works for the defendant. Everybody works for somebody. I mean, there's arguments that, could say the cook had reason not to be truthful, but if you had the details about the last cleaning and inspection of the floor before the fall, then that would show something that was ongoing, that wasn't a result of anybody wanting to suggest testimony in one way or another. I'm not saying that that happened, but I'm saying there is a reason that case law has developed so that there is some record of inspections, cleaning inspections, et cetera.
But also in this case, Your Honor, we have the co-worker who is a non-party, Daniel Garcia, who said the first time they were in the cold room, there was nothing there.
Counsel, but what you're asking a court to do in this instance then is to become the trier of fact and say, I believe the defendant's two witnesses over the plaintiff's witness. And our case law does not permit us to do that.
But in this case, the plaintiff himself testified that the first time he went into the cold room, he didn't notice anything either.
But then he went out of the cold room to get more boxes. They took time to go back out, to load the truck, to load the hand truck, to then come back in, to then take things off of the hand truck, which is what he says happens before he grabs the bag of flour or whatever it was to go into the cold room. In that amount of time, something may have ended up on the floor, or something may have already been there that he stepped around.
Well, my
And
answer,
in fact, the cook testified that they were going in and out of the cold room while they were making the deliveries.
I'm sorry, Your Honor, I believe her testimony is it's in the record. Her testimony was nobody went in the cold room while they were making the delivery. And if we go to the...
But there had been people going in and out of that cold room prior to the delivery. She testified she had just come out of the cold room with some items to cook, eggs and something else.
But if we're going to go to the point Your Honor just made about he was in delivery and something happened during that.
You're
So
saying whether or
counsel-
not you had constructive notice, whether there was actual or constructive notice, you're saying you didn't have sufficient time to be able to discover anything.
And if that's the theory of the case, that something spilled while he was making the delivery, everything that happened the night before kind of loses its relevance, because then we're dealing with what happened during that space. And anything they're saying, the clip...
I want to be clear because I understand where you're going with this, and I don't think that's what this court is saying. We don't know whether there was a greasy substance. The plaintiff said that he stepped on some. I heard no evidence that this room was so tiny that you could only step in the same steps every time you walked into this room. So the fact that the first time he went in, he didn't slip, perhaps he stepped in with the left foot the first time and stepped in with the right foot the second time. I don't know. The point is the second time, he slipped and fell.
Okay. So that also wasn't the reason for the trial court's ruling, though, in the first instance.
You'll have
on
some
that issue of
rebuttal.
fact.
You'll have some rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Michael Zhu, appellate counsel for Grover Fenster-Stock, attorney of record for the plaintiff, Mr. Chalice. I think the problem here stems from their original motion. They moved to dismiss, arguing that my client didn't slip on anything. He was carrying the truck in, the hand cart, and something happens to the cart where the bag of flour falls on him. The cook testifies there was nothing on the floor. He didn't slip. End of case. So they moved on that ground. They moved purely with the argument that there was no substance on the floor at the time of the accident. The plaintiff did not slip. Therefore, we should get summary judgment. And the coworker, the plaintiff's coworker, says the same thing. We oppose, arguing that they didn't meet their prima facie. There's no affidavit from anyone with personal knowledge as to when the floor was last cleaned or inspected. And there are issues of fact as to cause and create. Reply affirmation says nothing about when the area was last cleaned or inspected. Nothing in their reply. They argue they're wrong. The testimony shows that there's nothing there, therefore, end of case. The trial court issues its order based on the papers, and the papers focus on whether there was an item on the floor that caused the slippery condition. The trial court correctly held that when you move for summary judgment as a defendant, you have to establish the absence of constructive notice by coming forward with evidence showing when the area was last inspected. My respondent's brief argued that point, that they failed to meet their prima facie burden. Their reply for the very first time says, oh, but we have a cook that says that she was there that morning. But the issue is unpreserved because they never met their prima facie burden in the first instance in the motion below, because they didn't move on that ground. They didn't move on the issue of absence of constructive notice. They moved on the issue of there was nothing there on the ground at the time. Therefore, the case should be dismissed. Now, even if they did move on that ground, I would submit that there still is no evidence of when the area was last cleaned or inspected. There's, obviously, as this panel knows, there was a dishwasher that cleans the kitchen floor the night before. And there's no statement or affirmation or sworn statement from the dishwasher indicating that he or she cleaned the night before, and when I was there in the morning, there was nothing there. So on that basis, we believe that the order of appeal from should be affirmed. Thank you.
Thank you.
Very briefly, counsel misstates the argument we made below. It wasn't just that there was nothing there. We made the same argument below that we made here in our briefs. As far as the issue of notice, Your Honor, if Your Honors are going to rule that me having an employee who looks there and says there's nothing there, that does not enough to make a prima facie case of notice. You know, that's the law, that's the law. In response to Your Honor, Your Honor's question, well, the cook is biased because...
I didn't say that.
Well, I thought somebody said something about the cook being potentially a biased
I didn't say that the cook was biased, but I said that one of the potentials is that the cook could be, they call it biased. That's why we need to have the inspection. I mean, that's why we
wouldn't the same thing
request-
apply to the dishwasher who is also an employee?
I beg your pardon?
If the dishwasher is
I
also
think
an
the
employee?
difference there would be that the dishwasher could establish that I cleaned this room at this particular time, as opposed to just general speculations that the dishwasher did it every single night. I think that's the difference here.
One thing comes up just right then in response to the actual fall, and the other is something that has been developed over time, an inspection record. That's what it is, not just something that you create because of the incident, but something that shows your pattern and practice with regard to the issue, which is what is absent here.
Thank you, Your Honor.
Alexi Home versus Union Mutual. May begin.
Thank you. Good afternoon, Your Honors. May it please the court. My name is Brian Barnes for the appellant Union Mutual Fire Insurance Company. I have two main points that I want to make as to why our position is that the court below erred when they denied our motion for summary judgment. The first is that this court issued a decision in 2021 that I believe Justice Renwick and Justice Manzanet, you were both on this panel. It was called Constantopoulos versus Union Mutual. It's a 2021 case from this court. Our position is that case is squarely on the facts of this one, and that the holding on that is binding. And my second point is there's a case that was recently decided by the federal court. It's called Lee versus Union Mutual Fire Insurance Company. And that case is distinguishable from this case and does not control here in the same way that Constantinopolis does. So in Constantinopolis, this court found on the same insurance company, the same application question, that a misrepresentation as to the number of apartment units at the premises. In that case, it was 3 represented on the application, 4 in practice. This court found that that was a material misrepresentation that supported rescinding the policy. You have the same thing here, except it's 3 versus 2.
Here, you don't have a certificate of occupancy, I believe.
There is no certificate of occupancy in this record.
So, here you have the 2016 guidelines that says living units, and then it also, it doesn't say apartment units. So first of all, I don't know what a living unit is, but neither one of those words is defined within the policy. Second, there is no certificate of occupancy for the building, or at least that apartment. So one wouldn't consider a place that there's no certificate of occupancy to be an apartment, because one considers an apartment to be a dwelling. So if you think of this as, oh, they said 2, not 3, okay, maybe you could say there's a misrepresentation, but how would that misrepresentation, or how would that difference be material? And if it's not material, then how do you succeed here?
Yeah, there's a lot there to unpack, Your Honor. Let me try to do it.
Okay.
So
you can unpack first the apartments with regard to neither of those words being defined.
Yeah. So the insurance law is clear, Your Honor. You don't need to define every term in, be it a policy.
No, only the significant ones.
I'm not sure that's how I would describe the law either, Your Honor. When you don't have a defined term.
So let me just, so you're talking about how many apartments there are here, are you not?
That is the question, correct?
And yet the word is not, the word that's used here is not apartment, it's living units.
When you're speaking with living in respect to what's in the underwriting guidelines, Your Honor, is that when you mean, because the application uses the term apartment unit, and then the underwriting guidelines say that the premium is set based on the number of units. It does say living units, right? I can't dispute that, but I think the underwriting guidelines are clear. And by the way, these are the same guidelines.
The underwriting guidelines that say living units?
Yeah, they talk about, if you look at the underwriting guidelines, which are at page 52 to 55 of the record, and what they say is that the apartment and dwelling liability class codes, which is what are assigned based on the number of apartment units that are disclosed on the application. This is in Lambert's affidavit when he describes how the underwriting process works. And it says from there, based on the number of living units, that's how the premium is developed.
How are you supposed to determine what a living unit is, where living unit is not defined? Apartments is not defined, and there's no certificate of occupancy, which under the law usually determines whether a particular unit should be lived in.
I think all you have to do in this case to make that determination is look at how the property was being used. The case law, even the Lee case that was just decided by the federal court.
Well, that doesn't completely help you here, since the plaintiff says that one of those units, she only had a lease for 2 units, not all 3, and said that the 3rd unit was used to store personal property.
So that's what the initial investigation that was done after the claim came in said. But if you look at the...
Well, actually, that was discerned before the claim, wasn't it?
No, I don't believe so, Your Honor. I think the claim came in and there was investigation done. The inspector went out and took a statement from the
But there was an inspection of this property before a policy was
right after
underwritten, right?
Yeah, it would have been shortly after, but it would have been in connection with the application process. And
it would have verified whether there were 2 or 3 units then, no?
No, that's actually not the purpose of the inspection.
The inspection.
Really?
After the person signs the policy is not to determine how many units are in the building?
That's correct.
For purposes of the policy? What is it for? What are they going to the building for?
If I may, go over my time.
Yes, yes.
If you look at the testimony of Mr. Lambert, what he says is...
No, that's not what I asked you. I asked you, what is the purpose of the insurance company inspecting the property? What's the purpose?
So the purpose of the inspection is they determined that the sidewalks, the electrical panels, these are the issues where most claims present. So what they do when they go out to look at the property is they try to identify it for potential claims and potential hazards.
Well, what would a
But isn't
potential
the-
claim be if not for the apartments? That's precisely what you're choosing to rescind the policy for now, is that they were not accurate about the number of apartments. But you're saying, but when you go to the inspection, that's not what you were looking for, not the number of apartments, even though that would be the main subject on which you would rescind the policy?
Your Honor, the
I'm
insurance
sorry,
company...
I'll give my colleague an
Well,
opportunity
I'll
to
just
ask a
add to
question.
that, and in fact, the premiums vary based upon the amount,
Exactly.
the amount of apartment units, right?
They do,
And that's part, look,
Living units.
insurance is all about risk assessment. And putting a dollar value on how much risk there is for a particular property. So clearly, there would be an indication from an insurance perspective for a higher premium if I have to safeguard 3 different units, 3 different people, potentially 6 different people, and more. The more people, the more units, the more risk. So how is it possible that verifying the number of units is not part of the duty before issuing a policy for a residential home?
So I don't disagree with you that the risk could change based on the number of units. What I do disagree with is the purpose of the inspection is to identify the primary risks associated with binding the policy, right? Someone slips and falls on a sidewalk.
The primary risks.
Right. If you look at the testimony, when they describe the process, they say these are landlords who are taking out these policies. They're rented to tenants. The tenants may or may not be there. The insured doesn't have the right to give access to the interior of the space to confirm how many apartment units there are. That's why they don't do it. They don't
That's
go.
not the only way to confirm how many apartment units are in a building.
So I want to point out a couple of concerns and also a couple of distinctions. So the issue before us is not whether or not the apartment on the first floor constituted an illegal occupancy. You know, the certificate of occupancy indicates very clearly that there were only 2 units allowed in this building, right? And we're not looking at that. We're not looking at violations of the C of O. We're not looking at the lack of alteration permits in order to expand the number of units. We're looking at an initial inspection where the inspector sees from the exterior that there are clearly three floors, and the photograph from the inside shows that there is a one on a door on the first level. But the inspector takes the word of the person who's accompanying him on the landlord's behalf and doesn't open that door and says, and accepts that this is a storage unit. So for purposes, so to that extent, one would question, is the actual occupancy a concern? Is that a material concern? Is there a material misrepresentation here where it said that there's 2 living units, 2 apartment units? Then you go to the underwriting guidelines where it references living units, but then I point to you the loss report with page 368 of the loss report, and I ask you, to what extent does waiver not apply here, where you have loss adjustment, loss of rent sale at the bottom of the page? It indicates, and this is the loss inspector, that he receives signed copies of the 2nd and 3rd floor tenant lease agreements showing that the tenants pay a combined rent in the amount of $4,400 per month, and then proceeds to do calculations dividing the $4,400 per month by 3, not by 2, but by 3, to show what the loss of rents is for this particular property. Don't you have waiver here from beginning to end where the fact that the representation on the application for insurance is 2, but where all through this, the insurer is surprised that there are 3 physical units?
So the way I would answer that, Your Honor, is At the time that inspection was done, the initial time the independent adjuster goes out there to look at the property, they're told by the representative of the insured that the first floor is not being used as an apartment. I don't know why they decided to divide it by 3 in that particular calculation. That's something that the adjuster did. I'm not sure what the reasoning is. But after that, they got the statement that said this is only used for storage. So it was unclear at that point whether that space had been rented out, because for a rescission, you have to look at the misrepresentation made at the time of the application.
Thank you. You can finish up anything on rebuttal. You may begin.
Thank you. Good afternoon, Your Honors. May it please the Court, my name is Craig Blumberg. I'm just going to hit on a few things. You went through a lot of the things that I was going to go through, but I really do want to point out that a lot of what you were asking is exactly what was decided by Judge Margot Brody in the Eastern District in determining that that question, number of apartment units, the exact same question, is ambiguous.
I'd like you to focus a little bit on rescission, which I don't think we question too much. The idea of whether or not they've rescinded, or there's the potential that they rescinded the policy by continuing, or they gave up, they can't rescind because they
You're
accepted.
talking about waiver.
Waiver, I'm sorry, that they waived because they accepted the,
Yes.
continued to accept the premiums.
I'm sorry, exactly what you said is exactly right. I will point out, and I don't think anybody referenced this, that in the record on page 670, there's a copy of the pertinent part of the underwriting guidelines that specifically say the quality of a risk determined by physical inspection, the purpose of the inspection is to ensure the risk has the actual number of units reported and to ensure that the structure meets program acceptability standards.
Is that from the 2009 or 2016 guidelines?
I dispute which underwriting guidelines apply here. And that is in the earlier one.
Which one is it that you read from?
That I know is from the, I think it's a 2009 one.
The
guideline.
2016 guidelines would be in place here.
Well, I think it was around the same time, and I know that defendant claims that the 2016 underwriting guidelines apply. I don't necessarily know if that's true.
Preceded the leasehold.
I'm sorry?
I do believe that not the leasehold, I do believe they preceded, the 2016 guidelines preceded the insurance application.
In any case, when an inspection is done, the purpose, the primary risk associated with the policy would be having to insure all of the apartments in the building. So that would be the number one issue that would be considered.
Right, and that's what I was going to get to, that the fact that these earlier guidelines specifically said this tells you how important that is. Because the following guidelines don't specifically say that, does not make this less important. You could see just how they
So are you
react
saying
to
that
that.
the 2009 and 2016 guidelines were both in effect at the same time?
What I'm saying-
Or that the 2016 guidelines replaced those 2009 guidelines?
No, what I'm saying is the importance, what guidelines are in effect, that's up to defendant to prove. I'm not even sure what the answer to that is because there's an overlapping in.
In other words, it sounds like what you're saying is inspections are what the companies do. That is what they do to determine whether their policies are viable.
Right.
And when they're going to inspect a building, they're inspecting it to see what the entire building is, not the number of apartments is key, regardless.
Right,
of
they are inspecting it to make sure that they want to insure the property based on the information they have. And clearly, it is important to Union Mutual to know how many apartments there are, because denying claims for misrepresentation in the application related to the number of apartments is not something that Union Mutual hasn't done in the past. It is very important, and that is specifically why they do these inspections. To then just simply say, well, we did this inspection, but we weren't looking at that. It's not what the purpose of these inspections are. It is to make sure that what is said in the application is what they have, and they are given the opportunity to inspect. They didn't have to inspect, but they did that, and because they inspected, it is a waiver. And I'd just like to just...
And then they also continued collecting premiums and then renewed the policy twice thereafter.
Yes, twice thereafter. Yes, twice thereafter they renewed. And I just want to point out, and I don't know that counsel made reference, the Lee case was affirmed less than 2 months ago in the Second Circuit Court of Appeals. And what's important in that, as it relates to misrepresentation and that question about the number of apartments, that court affirmed the fact that it is an objective standard. It's not even a subjective standard. So that question, in and of itself, is ambiguous for every single insured that has completed that application. And any material misrepresentation that Union Mutual may claim existed in that answer, they can't. It is a material misrepresentation that they cannot rely on any further.
Thank you.
Thank you.
Okay, I know my time is brief. Mr. Blumberg just argued that the question is ambiguous no matter what on all facts and circumstances. That's not what the New York insurance law says. You have to look at the context to determine if a term is ambiguous. It's not ambiguous in total across all factual circumstances. You have to have two reasonable interpretations of the term based on the facts that are presented. The second point I want to make is based on the initial underwriting inspection, which is that you can't determine how many apartment units there are at a building unless you have the ability to go into the units, to go behind the closed doors and see what's there. There was a reference that was made in the earlier questioning to there was a number 1 on a door and they didn't see what was behind it, they didn't go in. Well, you don't know if there's an apartment unit there unless you go inside the space and see, does it have a kitchen? Does it have bedrooms? Does it have bathrooms? In this case, that wasn't done. The underwriting inspection.
Thank you very much.
Thank you, Your Honor.
Thank you both. DeProspo versus Nixon Cochran. You may begin.
Good afternoon, Your Honors. May it please the Court. My name is Anthony Bono from Camacho Moro, LLP, on behalf of the defendant appellants. I'm going to begin with the issue of the untimeliness of the motion that was made. The lower court overlooked the fact that the motion was served on time on December 7th, 2021, which is the controlling factor as determining timeliness of a motion. There was obviously a debacle in terms of getting this motion e-filed.
Well, counsel, let's assume that we agree with you that the motion was filed timely. As to the merits.
Sure. So on the issue of the merits, this case is the facts in this case are clear that Ms. Nixon Cochran was a quintessential independent contractor. Obviously, her job was to make deliveries of the auto parts around the neighborhood in the Bronx. What the facts establish here is that
Did she collect workers' compensation?
yeah, she did collect workers' compensation.
So do independent contractors normally qualify for workers' compensation when they're injured on the job?
Typically not. Here the
So
circumstances.
What's so special about her that she qualified for workers' compensation, not being an employee?
And that fact would not create an issue of fact about whether she is in fact an independent contractor or not.
I can appreciate that. So she was awarded workers' compensation benefits on default. The carrier didn't oppose the claim. That's obvious. That wasn't a part of the record. So
That doesn't
That's
help
how it
you.
works.
That doesn't help you because all that tells me is perhaps the employee said, "Don't fight it, let it go." So that doesn't prove anything one way or the other.
I agree. It doesn't prove anything.
So
one way or
tell
another.
me what in the record clearly, as you said, she is a quintessential clear independent contractor. Tell me why.
Well, the only instructions that she was given with respect to the performance of the work was where to deliver the products. She was given
She did work 6 days a week, and am I right? How many days a week did she work?
yeah, this was her day job. This is how she earned her income.
So let me, go ahead.
she-
In 8 hours a day she worked?
Full
time?
Yeah, so essentially she was putting in a full week's worth of work at her discretion.
And there were forms that,
I'm sorry.
She worked full-time. Yes. She worked on a fixed schedule. Yes. She was injured while making a delivery to an individual who was waiting for her on the street and she was directed to go to that particular person by Beto, whatever the supervisor was.
Right.
On her
And
way home.
she received workers' compensation through that, and it was on her way home that she was doing that. I mean, all of those things point to no independence. So what else is there?
So,
needs
so
to-
all these factors that we're referring to here are incidental factors of
Incidental
control.
factors, not factors that suggest that she is the employee and not an independent contractor.
Well, I would argue
Doesn't
that
the case law actually say the opposite, that the items that my colleague has just gone through with you are indeed the factors that the court must consider in determining whether a claim of independent contractor is true or not?
I agree. They are
And
factors.
you check, your side checks every single box on, is there this, is there that? And every single item is present here. So it seems to me that's an issue of fact.
I understand that. I understand the court's perspective on that issue. However, the key issue here is the control over the means and methods of carrying out the work. And here, all she was
It's
provided.
delivery. What means and methods? You get in the car and you drive and you drop off whatever product has been given to you. This ain't rocket science.
I agree with that.
This
And
is a delivery job.
right, and the case law from the first
So
department.
there's no means and methods. Get in your car, drive the product to the location.
I agree with that, and if I may, the case law from the first department in DeFeo versus Frank Lambie from 1989 is a similar fact pattern. The driver was told to deliver goods inside or outside of the premises where the goods were being delivered, and the court found that that was mere incidental control. It's essentially
But
tantamount to
maybe that
providing an address.
particular, I can't remember the facts in that, but maybe that individual wasn't working full-time. Maybe that individual wasn't on a fixed schedule. Here you have those factors, plus the fact that they were specifically instructed with what to do when they arrived at the space. Those are the factors that are considered and looked at in determining whether or not someone is an independent contractor. And I'm asking, I think we're all asking, what do you have that takes this person outside of the realm of being an employee and into the realm of being an independent contractor? I'll let you think about that, and you can answer in rebuttal.
Thank you.
Good afternoon, Your Honors. My name's Toby Salatolo, and I represent the plaintiff respondent, Justin DeProspo, and his mother. He was an infant when this action was commenced, and I filed a joint brief with Mr. Chaffetz, who represents the other plaintiffs. It's late in the day, and I think the court understands that Ms. Nixon was anything but the quintessential independent contractor. She does check all the boxes, and also I just want to cite the one case, Edwards Rosario, which is a 2018, I think Judge Renwick was on that case. They even added additional things to that, and they said, so there's really like 8 boxes, and she checks all of them, and unless you have any questions for me, I'll rest on the brief.
Thank you.
Good afternoon, Your Honors. Lawrence Chaffetz, Chaffetz & Chaffetz, attorneys for the respondent, the state of Richard Santiago, who passed away as a result of this accident, and his wife, Eileen Santiago. We support and adopt their arguments. Thank you.
Thank you.
To answer your question, under the precedent that I referenced before, DeFeo and as well as Santella versus Andrews, a 1999 case from this department, these delivery drivers who are simply told where to go have been found to be independent contractors, and I believe that's the circumstances here. I understand that there's other facts in this record that are not necessarily addressed in those prior decisions.
Just so that I'm clear, so you don't think it's important, you don't think it's a significant fact that the person worked full-time for this company, and you don't think that it's a significant fact that this person worked on a fixed schedule for this company. Is that what you're saying? Those are not relevant factors.
I believe they're relevant, but my position on those is that that's her choice. She chose to come in 6 days a week. There was no penalty if she didn't. There was no penalty for
So
her.
under case law, you don't think that those factors are relevant?
I agree that they're relevant. I think that they are less significant than the means and methods, the control over the means and methods. Thank you.
Thank you all. Diaz versus Klausner.
Good afternoon, Your Honors. My name is Karis Lund of Kahanenfeld, and I represent the defendant appellant. I'd like to start with defendant's arguments regarding plaintiff's left shoulder, left hip, and lumbar injuries. Regarding these injuries, defendant met their burden of showing that these were not causally related to the accident. And in response, plaintiff did not oppose these arguments at all. And based on case law, that means that plaintiff has...
Well, she conceded that the lumbar, that those three areas were not serious injury. And under our case law, if we find serious injury on other parts of the body, they get to be considered, unless there's a reason that you can show that there is no causal relationship at all.
Yes, so you're right that they can come in if they're not serious injury, if they can prove another serious injury, but it has to be causally related. And we are arguing that in their motion below, they didn't actually say anything regarding causation. And we made...
Well, the doctors, I thought, said that there were some limitations of range of motion and that they were causally related to the accident.
The range of motion goes to serious injury, but...
I understand, but insofar as we do have 2 items of serious injury here. So now the question is, of the other asserted issues, lumbar, the hip, I think there's one other, with regard to those, what in the record shows us that there is no causal connection? And it seems to me my review, the only real one here, is the hip injury in light of her pre-existing congenital hip condition and the hip replacement she had a few years before this accident, and the fact that the records, the only thing I could find about the hip was that she had a bruise on it, but that it had not dislocated, although she fell on it.
That's correct, Your Honor.
Okay.
But regarding the lumbar injuries and the left shoulder injuries, Dr. Devine, our biomechanist, noted that the impact could not actually have caused those injuries.
So, counsel, I don't know, are you actually accurate? Did plaintiff raise an issue of fact as to causation per the left shoulder, left hip, and lumbar spine based on Dr. Wright's findings of significant reductions that existed but weren't enough to be serious injuries? I thought that there was a contest.
So Dr. Wright doesn't actually talk about which injuries he's talking about. So he says...
Doesn't he say that plaintiff never had pain in those body parts prior to the accident?
But he does not opine that those injuries were caused by the accident.
Let me see, she had no problem before, she get hit by a car, knocked on her side, and then she has a problem.
Right, but Dr. Wright also only...
And this is not a woman who sat and just typed, right? She was a home health aide.
Yes, correct.
So she has to pick up her patient and help with all sorts of heavy lifting, right?
You're right.
She was able to do that job before this accident, and following the accident can work no more.
But it's also notable that both in the ambulance and at the hospital, she didn't mention pain to her neck or to her...
But sometimes these things, I mean, if you've done this work enough, you know that these things don't present themselves immediately. Could be 24 hours, 48 hours.
I'll also note that Dr. Wright's report, in his report, he says that plaintiff was asymptomatic before the accident, but he only relies on what plaintiff tells him. He doesn't actually review plaintiff's pre-accident medical reports. So he's relying exclusively on plaintiff who's interested in this case.
I don't understand. If there was no prior medical history, then how do you review no prior medical history?
Well, Dr. Wright was a treating physician on her.
Yes.
And so you would assume that he would review her pre-existing medical history. I mean, people go to the doctor when they have, whatever sorts of injuries.
Are you suggesting that there's something in her past medical history that he failed to allude to that you are aware of? Because otherwise, then it's just speculation on your part that there must have been something, and he didn't talk about it.
I mean, it's also speculation on his part. He notes that, for example, Dr. Kolb noted that there was degeneration, but then he just says, well, that's not the cause of the accident, even though Dr. Kolb never made those arguments about causation. And so I think Dr. Wright does a lot of conclusory.
How old is this patient?
I believe in her 50s.
Okay.
Not when
At the
the
time of
accident
the
happened.
accident, she was 41.
Yes, in the time of the accident, 41.
Okay.
I'd also like to note that on the injuries of the cervical spine, for example, defendant also met their burden here to show that these injuries were not causally related to the accident. And in response, Dr. Samela, plaintiff's expert, conclusorily does not explain his conclusions about degeneration that even though he said it wasn't significant, but he didn't explain that, and case law requires that he do so. Thank you.
Good afternoon, Your Honors. Andrea Krugman on behalf of plaintiff respondent.
Just, counsel, before, I don't want to miss what your adversary just said. With respect to the C-spine, I'm so used to saying C-spine that now I'm stuttering. Is that actually true that there were no significant limitations? Because from what I'm seeing here, Dr. Klein found a 15-degree loss of flexion, loss of extension, loss of rotation, and loss of lateral flexion in the C-spine.
That is true, Your Honor, he did.
Over
and,
10 is deemed significant, am I right?
That's true. Just a couple of things I want to point out. Defendants actually had 2 years of prior meds of the plaintiffs that have absolutely no indication of any prior medical history that's relevant. Your Honors were spot on the you prove one, you get them all. On the shoulder, the left shoulder, the lumbar spine, and the
Why
left
don't
hip,
you
but
address the hip injury? Because I saw nothing in the reports, expert affidavits back and forth of any injury that to her hip as a result of this, other than soreness, which one would expect if you get hit on your side.
Absolutely, and we concede that those in and of themselves don't make serious injury. However, as you know, the case law says if you prove one, you can still get damages on all of the injuries. So those injuries...
But there should be something in the medical records that references that. My review of the medical records, I believe the hip was mentioned once, maybe twice in Dr. Wright's report, just in the beginning, just saying, yes, she got hit and she complained of pain, but there was nothing beyond that.
Right, she had a bruise, and she was essentially okay after that, but there was some pain related to... I mean, she did actually fall, and she fell onto that side, so there was some.
Even when you include these things, you don't get, a finding for pain. I mean, because you had a little bit of pain.
And that would be up to a jury, for sure. But the bigger issue here is that defendants never made their prima facie showing of a lack of serious injury on all counts. There was their biomechanical said the right shoulder injury could actually be causally related. There was no prior. Their examining orthopedist said that 2 years post-accident, she still had 50% loss of range of motion in her right shoulder, so that shows permanency. The C-spine, Dr. Samela 100% said there is a lack of degeneration, and he saw it when he actually looked at the spine. You're you're comparing looking at an MRI versus looking at the actual spine. And looking at the actual spine trumps looking at a film. No other questions, I'll rest on the papers.
Thank you.
I'll just note that there's no case law that says looking at the spine is any more accurate than looking at MRI
There's no
images.
question that looking directly at, come
But,
on.
I mean,
Are you
MRI, I'll just say
An
MRI.
operative report versus an MRI, you see no distinction, no qualitative distinction between the two?
Well, I think the qualitative distinction is that on MRI findings, you can see different things that you can see versus like looking at someone's spine.
So your response would be more nuanced, right?
Yes.
Okay.
Thank you.
Thanks.
Thank you both. San Miguel versus Grimaldi.
Good afternoon, Your Honors. Belinda Ricky of Vigorito Barker for Dr. Grimaldi. I need to clarify a point that we misstated in our brief, and I apologize to the court for that misstatement. The court below did dismiss the mother's lack of informed consent claim for emotional distress, but the court did not explain the basis of that dismissal, and on page 28 of the record of appeal, which is part of the decision, there's a discussion by the court, and it's ambiguous, it's unclear whether what the rationale or the reasoning behind the dismissal of the lack of informed consent claim for the emotional distress was based on. So what we would be looking for is a clear statement that in this case, with this mother, she is not entitled to assert a claim of lack of informed consent for emotional distress caused by the pain and suffering of her infant, because there's no evidence of an independent injury to her. So I just wanted to, that's really the basis of the appeal. And now the plaintiff has...
Case law seems rather arcane, but it is what the case law seems to be. Why don't you move on to your next point?
Yeah, and there's only, I'll be very brief, Your Honor. There's only one other point. The respondent, the plaintiff, has suggested that a reason for making this cause of action compensable is when the mother has suffered a sort of a heightened or a higher or more severe sense of emotional distress. And I don't believe that that's supported by any case law. There are two Court of Appeals cases that we cited where they really talk about extreme emotional distress on the part of the parents watching their infants suffer. And both of the courts held that for various reasons, limits need to be put on what is compensable and what is not. And that hasn't really changed. And so our argument would be that that should not be expanded because that is the law at the present time.
Thank you.
Thank you.
Good afternoon. May it please the court. My name is Samantha Quinn. I'm here on behalf of St. Barnabas Hospital. I do want to point out that in the original brief, there were 2 points we don't need to address. One has been conceded by opposing counsel. The first, in the original brief about the vicarious liability, we concede that Riviello versus Waldron controls. That does leave just 1 point, which is proximate cause, and it is our position that that is dispositive in this case based upon the case law, that there's no non-speculative way to find proximate cause as to nursing departures.
This is the nursing departures of Nurse Johnson you're speaking about?
Of Nurse Johnson or any other nurse.
Or any other nurse.
Essentially.
So this woman went into the hospital some days before, and at some point there was the difference in the deceleration of the heart rate. One, I think it happened when Dr. Grimaldi was there in the wee hours of the morning. With regard to when Nurse Johnson was there, it happened at 7:47. And yet, there was no C-section until 2.5 hours later at 10 o'clock or something around that time. How is there not a clear issue with regard to the medical malpractice at 7:47 with regard to Nurse Johnson, and prior to that, where there was a previous deceleration with regard to the doctor?
Respectfully, Your Honor, I'm not going to dispute that there are issues of fact as to, whether there was a departure or not. This is strictly a proximate cause argument, and because
Yes, whether that was the proximate cause of, oh, okay, of the,
and I want to respond to your question. So Dr. Grimaldi was in attendance with a patient at 1:41 a.m., 4:17 a.m., 5:59 a.m., 7:01 a.m. CNM Croco's shift began at 8 a.m. Both Dr. Grimaldi and CNM Croco testified that they would have done rounds at 8 a.m. and reviewed everything, that they had access to the fetal monitoring strip.
except well, first of all, this happened at 7:47, first of all. So at 7:47, when this fetal monitor is going up and down and decelerating, you don't wait for somebody to come in, you make the phone call at that time. And I believe, Dr. Croco, I believe there's testimony that says she started her shift at 8. She didn't come in at 8 because there was so much going on that she was so busy that she would have gone on elsewhere, not necessarily
Well, respectfully,
come in
she
there.
testified that her shift started at 8. Her custom and practice would be to review the chart and the fetal monitoring strips before seeing the patient. This is her testimony at 17:47, 59, and 78.
Does she say that she actually did it? Because you are saying it is her custom and practice. That's nice that that's her custom and practice, but I want to know what she did on this day. This baby should not have died. There's no reason why this baby died, okay? This woman was in labor for almost 36 hours, and there was not checks of the baby strip. The fetal monitoring strips were not being checked. There were decelerations throughout that day, and the nurses did not notify the doctors.
Respectfully, Your Honor, when the doctor and the nurse midwife were made aware at 9:44 a.m.
That was already the child had been experiencing distress for hours.
That was not what the plaintiff's expert specified. Was the departure as to nursing, essentially said they should have been called to have ascertained the status of the fetus to determine whether induction of labor should continue.
When was that? When should that have happened?
Well, that they don't specify.
Well, it's 7:47 when the deceleration occurred, so why would they not do it then? I mean, isn't
But
that
they
the
were
purpose?
made
May I
aware-
speak just a moment? Isn't that the purpose of watching these tapes? When you see the deceleration, that indicates something. It was at 7:47 that Johnson, the nurse, saw the deceleration, and no one was called. Why isn't that a proximate cause?
Respectfully, Your Honor, when they were made aware at 9:44, 18 minutes went by where Pitocin was still administered, she was still pushing, and it was over 35 minutes before the delivery was.
That's a problem.
Is it proper to?
But that's, I'm not saying that, this is the doctor and the nurse midwife who are in charge here, and we are vicariously.
You continue. We asked you a question before, and you continue to go to when the doctor's in the room. The problem is that there were things happening before that the doctors should have been made aware of. There are no notes, because I went through this record very carefully. There are no notes. Dr. Grimaldi goes in at 4:17, performs a pelvic exam, but he has no notes regarding the status of the fetus or decelerations of heart rate, nothing. There's no notes saying that they did any checks to make sure that the fetus was well.
Respectfully, Your Honor, Dr. Grimaldi.
And at that point, she was 36 hours in labor, and the Pitocin had been administered already, and it was not progressing very quickly. She was only at 4 centimeters.
Respectfully, Your Honor, the hospital has vicarious liability for Dr. Grimaldi and CNM Croco. What I'm talking about is very specific here, that there are no allegations of nursing, independent nursing negligence that can be proximately related to the damages. I will.
What about the delay in the care, though, a delay in calling the doctor? I think that that's the issue.
But when the
From
doctors were made,
7:47 to 10 a.m.
when the doctors and the nurse midwife were made aware at 9:44.
But I just want you to just try to focus, and I know that that's what my colleague is asking you also. I've asked repeatedly about 7:47. That's when the decelerations occurred, and Nurse Johnson was on duty. Perhaps the experts didn't refer to that. Maybe that's what you're trying to say. I'm not sure. But at 7:47, no one made a call to either Dr. Grimaldi or the midwife Croco. Nothing was done.
And the
that
plaintiffs-
deceleration could be is approximate cause. You're not addressing that.
And the plaintiff's expert, to add on to what my colleague just said, the plaintiff's expert pointed to that in particular as a deviation from the standard of care.
But the issue is that a nurse does not have the ability to call a cesarean section or to.
The
To
nurse
call the
has the
doctor.
ability to call the
I
doctor.
understand,
You
but
just
when the doctors were called, they did not
the
do
nurse
it.
didn't call the doctors until later.
Does that make a difference to you that they waited about, let me see, from
2
7:47 to notify the doctors at whatever it was, minutes to 10? That makes no difference in your mind? That had an effect at at the outcome here?
Honestly, there's testimony and evidence in the record that they were, first of all, they had access to the monitoring strips. They were aware during rounds. They would have reviewed the certified nurse midwife and.
Access does not mean that there
But
is
that they would
nothing
have
that they
reviewed
have
during 8 a.m.
testified.
rounds. There's
They do
absolute
not
testimony.
testify that they do it. They say that that is their practice, their standard procedure, and there's also testimony here that they were busy. That they were busy, so they had other patients to see.
Understand that. And
Before a jury hears that they're busy, and that their standard of practice is that they review it, but can they say that they reviewed it? Is that?
Dr. Grimaldi testified that there are always rounds at 8 a.m. where the patients are discussed. That's 8 a.m., that's 13 minutes after this allegation. Always rounds where the patients are discussed. That is her testimony at 1663 and 1664.
And how many patients were in this ward at that time? Because they can't discuss at 8 o'clock every patient on that floor, right? So telling me that at 8 o'clock their standard practice is that they come down and do rounds and discuss the cases doesn't tell me and doesn't tell this court at what time Dr. Grimaldi actually put her eyes to the monitoring strips of this baby and did something about it. That's the issue.
That is the issue, but the legal proximate cause is that her expert says you should have notified the doctor or the nurse midwife. And the problem is
At 7:47?
then you have to, what would have happened then? And what did happen when they were ultimately notified was there was further delay. There was
Right,
18
but it didn't
minutes
happen
of
at
delay.
7:47. It didn't happen then. It happened at 10 o'clock.
CNM Croker was on duty.
The one time we know it happened is at 10 o'clock, which is an hour and something later. That's the time that they actually say, we know we were there.
9:44 a.m. was when
Right.
CNM Croker was there, and that was a good 37 minutes before the delivery was effectual.
That was
What
2
about the
hours
2 hours?
after
I mean, you keep trying to-
7:47. That is the critical time. The baby is in danger at that moment, and it required urgent action.
But when
Not,
the,
call
when the
this-
doctors came on, they did not act urgently. That's my point. That's where the legal
Counsel,
cause
there is a
was lacking.
distinction between being on duty and dealing, as my colleagues have indicated, there's a distinction between arriving on time to do your job, having a whole ward of people to work with, and knowing that this is how you triage. She was not identified as a triage patient. The baby was already, in crisis. The doctor wasn't told, and the midwife wasn't told that the crisis was accelerating. Therefore, this was most likely not at the top of their agenda. And this is the problem that everyone is trying to ask you to address and to acknowledge.
And what I'm trying to respond is that when the problem was brought to their attention at 9:44 a.m.,
2 hours
there was nothing done for another 37, 38 minutes.
You're
That's where the
saying, your
proximate
doctors are
cause.
saying that there is no proximate cause because once those doctors came in, there was still nothing done.
a delay,
But plaintiff's expert has said that 7:47, when these variations were happening in the fetal monitor, that's when somebody should have been called and they weren't. Thank you.
Thank you.
I think it's good evening.
Unfortunately, it is.
I'm Annette Hassapidis, appearing for the plaintiff respondent. Turning first to Defendant Grimaldi's arguments, I don't know if the court fully appreciated what counsel for Defendant Grimaldi said. He's essentially said that they believe that the judge actually dismissed the cause of action by the mother for lack of informed consent with respect to the baby, and they're seeking clarification of that on appeal, making them essentially not aggrieved. Now, I will tell you, it's not in the record, it's not in the briefs that I spent reviewing after drafting, and for hours this morning, as the court officers can tell you, it was raised 20 minutes before my argument when I was stepping in and out with counsel. It was the first time that this issue was raised. I would ask the court to completely disregard it, not just because of the timing of it, but if the judge made a mistake, and I submit to you that he did not, it's the subject of a motion to re-argue in front of the lower court. So I would ask that the court not only not address it, but leave it to the lower court. The judge's decision says he denied the motion for summary judgment with respect to plaintiff's lack of informed consent claim, and he dismissed the fourth cause of action. Leave it to the lower court to figure out the parameters of that. We've asked the court essentially to extend the law with respect to lack of informed consent. Now, the defendants have argued that because where a baby survives and has a medical malpractice claim, the mother cannot assert a claim for emotional injury. And this defendant has argued that the mother should also, that the mother cannot raise the claim because the baby's born alive, and it's a lack of informed consent claim because informed consent is a species of medical malpractice. Now, the set of facts that address the mother's pain and emotional harm from lack of informed consent is distinctly different than medical malpractice. The mother is removed from the chain of the events that give rise to the medical malpractice. With lack of informed consent, her emotional injuries are different. This woman was hospitalized at Bellevue for 5 days because of the grief and the guilt from giving consent, albeit unwittingly and uninformed, to the use of the vacuum extractor and other procedures in this case. And we'd submit to you that just as in Broadnax, where the Court of Appeals saw that there was a gap that needed to be filled, a lack of logic, if you will, between certain causes of action and whether or not emotional injuries.
What you're asking us to do, is it really to fill a gap or is it to overturn precedent?
I'm not asking you to overturn precedent. No court has addressed it. It's not that there's no decision out there. The cases that have been cited here do not, the courts weren't asked to address lack of informed consent and whether or not a purely emotional claim of injuries could be brought. Counsel has also argued that we've made an argument that because my client's injuries were heightened, that there has to be a heightened burden of proof. We've made no such claim. That goes to the weight of the evidence. It's our position that because the mother stands within the chain of events that causes the child's harm with lack of informed consent, as opposed to medical malpractice, she suffers a unique set of injuries that is distinct from an emotional pain that she might feel as a result of medical malpractice. She plays no role in that.
Well, I'm just wondering, counsel, what would be our basis for expanding it? Is that just because we have more knowledge of science and psychology and how these things affect people, or is there some legal basis for us doing that?
There should be no difference whether the baby is born alive or not. The distinction here that they're making is because a mother cannot recover for emotional harm when the baby is born. I feel like it's a conundrum that I keep getting confused in my mind. When the baby is born alive, the mother cannot recover for purely emotional harm. If the baby dies in utero, she can recover for emotional harm under Broadnax. The defendants have argued that if the baby dies in utero, she can recover for her emotional harm, but because the baby lived, albeit 10 days, she cannot. And that is a line.
The child had to be resuscitated, correct?
Yes, the child had to be resuscitated. The baby could not breathe on its own, had a terrible APGAR scores. So because the defendants...
So the child technically was not born alive.
Right, and Broadnax said that this was the gap that similar gap that they wanted to fill. They saw an injustice here from the mother being denied of an ability to recover because she had a stillborn baby. She could, and under Broadnax, they said, before Broadnax, if it was a medical malpractice claim and the baby was stillborn, there was no recovery. So this is analogous. And again, this is unique in terms of medical malpractice versus informed consent. My client has to live with the fact that she gave consent. She had been begging for a C-section, but she ultimately gave a consent that was not informed. And she should be able to recover for that pain and suffering. Now, I see that I'm over my time, and I do appreciate the court's indulgence. Can I turn briefly, unless the court has questions with respect to Defendant Grimaldi, to the St. Barnabas arguments? Thank you. Give me a moment. Okay. This is not whether or not there's a question of fact does not turn on the case law. This is a fact-dependent case. My client was in labor for 42 hours, not 36. 42. So I think that that's important to point out. It's interesting that the court has, focused on 747. There were fetal decelerations noted earlier, and our expert at page 2079 of the record at paragraph 4 says there were fetal decelerations. No progress of labor was determined.
As 4:17, right?
I'm sorry, sir?
As early as 4:17 a.m.?
3:23 p.m. On January, the previous day. No examination was performed. Nothing was calculated to determine the medical likelihood that Pitocin would result in a vaginal delivery or to determine the safety to the fetus. All a departure from standard of care, according to our expert as nurses. Now, at 747, and that's our expert addresses the 747 entry at page 2080 of the record. He says that there were decelerations, and again, no one was notified. No one has argued, the plaintiffs have never argued that the nurses had an obligation to schedule a C-section or schedule any...
Call the doctor.
No, call
the
the
midwife.
doctor. Call the doctor. And the fact that Dr. Grimaldi said it was her practice to do X and Y and Z is irrelevant. What matters is that no one called the doctor.
How do you respond to the hospital's position that once the doctors were called, they delayed anyway?
Well,
that breaks the chain.
It doesn't break the chain. They're joint tortfeasors, for one thing. They're joint tortfeasors. They all caused and contributed to the delay. This is about whether or not the nurses were liable. There's no superseding cause. They all caused and contributed to the delay. No, they're not arguing that because Dr. Grimaldi could have done something, they can't be liable. They can't make that argument because they're all responsible. That's why the nurses are there monitoring the fetal decelerations and why the nurses are obligated to notify the physician. I'd point out also that the defendants have argued that we did not raise a question of fact. The court, I'm sure, has reviewed the plaintiff's expert affidavit at pages 51 to 53 of the record. It's about 3 paragraphs. It only addresses the entry of 7:47 a.m. with respect to Nurse Johnson and says that was appropriate, addresses no other entries with specificity and says there's nothing to indicate that the nursing care was not appropriate. That's conclusory. But if that made out a prima facie case, how could my expert's affirmation be inadequate to raise a question of fact? And my final point, and again, I appreciate the court's indulgence because it is late, causation. The defendants have argued that we failed to specify what could have or should have been done. I mean, I think the court gets the obvious, order an immediate C-section, right? What would have happened had this not happened? But just to be sure and to point out to the court where our expert referenced it, at page 2083 of the record, our expert said that the failure to perform a timely C-section caused the infant plaintiff to be subjected to protracted intrauterine hypoxia and trauma for 5 hours of second-stage labor. At page 2085, he says that the lack of a timely and appropriate evaluation of the plaintiff and infant plaintiff for a departure that resulted in the ultimate death as a result of neonatal encephalopathy.
And that's what the cause of death was on the autopsy.
Correct, which is as a result of hypoxia, intrauterine hypoxia. And then at page 2086, and again, to address the argument that there's no evidence of causation here with respect to the departures, Dr. DeFazio says that the departures deprived the infant plaintiff of the opportunity to avoid irreparable injuries and death, and that he would have avoided brain damage and death but for these departures. Again, I thank the court for its indulgence. Unless you have questions, I will rest on the brief.
Thank you.
Thank you.
Very briefly, Your Honors. The mother is always in the chain of events in giving an informed consent in every situation. There's nothing unusual about that in this case. So for that to be the sort of the turning wheel point at which this doctrine changes or is added to, on that basis, doesn't make sense. Lack of informed consent, we've cited the cases, is a species of medical malpractice. It's the same as medical malpractice, essentially. It arises out of medical malpractice. So
It's not the same.
It's not the same.
No.
It's not the same, but it's very much affiliated with and attached to medical malpractice because it has to deal with the consent for medical treatment. And that's what the case law has held. In terms of whether the doctrine is applicable only to medical malpractice, that's not the case. We cited Tobin versus Grossman. That was an automobile accident case. The infant was severely hurt in an accident, an automobile accident. The parents suffered enormously, according to the case, watching their child suffer. And that was not compensable in any way, simply because that's what the doctrine has been. Perhaps it's antiquated, but that is what the doctrine is. And were this court to expand it, it appears, to me anyway, that it would be setting a new precedent. Thank you.
We do that from time to time.
Yes,
Why
you-
shouldn't we here?
I understand.
Why should the case that you just discussed doesn't really raise similar fact pattern, right?
It's not, I was only pointing it out, Your Honor, to point out that it's not a medical malpractice case. The doctrine applies not just to medical malpractice, it applies in other situations as well. That's the only reason I cited that case.
Thank you.
Okay, thank you.
I just have one point in response. And just to make the record clear, we stated at the beginning, we're not arguing no question of fact. This is a very purely legal argument that in order to have a failure to notify constitute the proximate cause of an injury, there has to be a non-speculative finding that the notification would have resulted in a certain action. And here, the actions that occurred at 9:44 a.m. defeat that conclusion because exactly what that expert says should have happened didn't happen even when that notification was made.
But isn't it certainly within the realm of possible in this fact pattern that if the doctors had been notified at 7:47 as opposed to close to 10 a.m., and the doctors had come in at 7:47, had tried the 2 suction attempts and those failed, they still would have been an hour and a half earlier than attempting a C-section at almost 10 o'clock, right? And so it seems to me that there is a question about had the doctors responded earlier and done exactly what they did later, would we have had a better outcome because that 2-hour lapse would have prevented 2 hours less of hypoxic conditions for the baby? That's all.
Respectfully, I believe that would be speculating and not sufficient for legal cause. Thank you.
Thank you all. Have a good evening.